Good morning, all. This application hearing is in the matter of CFI 015-2025 and is being held by way of video conference before His Excellency Justice Rene Lemiere, with the sitting of the hearing taking place in Dubai. Any orders or directions made during the course or after this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by Maysan Partners UK. Lead counsel is Mr. Rumen Cholokov, and the defendant is a litigant in person represented by Dr. Jorge Natividad Maqueda. Thank you, Your Honor.
All right, thank you. Good morning to you all. Now, Mr. Cholikov, this is your application, so please proceed.
Indeed. Thank you, Your Honor. I appear on behalf of Ward Holdings Limited, the claimant and applicant today. Ward Holdings is the owner of the Waldorf Astoria Hotel in the DRC. The defendant appears on behalf of Meshico Corporation, although we'll get to the point about the name in due course in my submissions. But ultimately, Meshico Corporation operates the Puerto 99 Mexican restaurant, which appears on podium 5 of the Waldorf Astoria Hotel. Effectively, this is a possession hearing because the premises that the restaurant occupies were leased from the Waldorf Astoria. And it is common ground, Your Honor, that the defendant has not paid any rent for around almost 2 years now. Subject to what the defendant has to say, and of course, Your Honor's observations and interventions, I believe, therefore, that the only issue before the court today is whether the defendant can rely on the defense of equitable set-off to resist the immediate possession on the basis of what I refer to as the air conditioning issue. And so, Your Honor, I propose to structure my submissions this morning in the following way. First, I'll go through the factual background relatively quickly by reference to the lease agreement, and also explain some of the key dates in the chronology over the past couple of years. Second, I'll make my primary legal submission that equitable set-off is not available and is not incorporated under the DIFC leasing law. But then I'm going to move on to my alternative submission that even if equitable set-off were incorporated within the DIFC leasing law through the common law, then it should not be allowed in this particular case. And there are two reasons for that, and I'll turn to the authorities on that. But ultimately, the test is not very well settled in the DSC, but I'll take you through what I've been able to find, and then I'll take you through the Australian approach and the English approach. But on all of them, I say the defense is unavailable. By way of housekeeping, Your Honor, yesterday there was a flurry of emails from the defendant to the registry, sending some documentation, which is obviously significantly out of time, but whatever was sent has been included by my instructing solicitors in the bundle, and it appears from page 490 onwards. Well, the claimant has not had an opportunity to review any of this material, except that there is a short skeleton argument that has clearly been prepared with assistance from generative AI. But I'll be making references and I'll be addressing that skeleton argument in the course of my submissions. Even though it's filed late, and we will be addressing it in any event. And that's at page 490.
I have the defendant's skeleton argument at page 14.
Ah, well, that may be a problem, Your Honor, because I've got it on page 490, which may mean that all of the references are not right.
Well, we'll see. We'll just see how we can cope with it.
I suppose so. We'll quickly discover, Your Honor, because the first document that I would like to take you is the lease agreement itself. And in my bundle, it's on page 94. And here's the moment of truth, I suppose.
94. All right, well, I seem to have it in different places. Just bear with me for a minute, Mr. Cholikov.
Certainly, yeah.
All right, well, I have the release agreement starting at page 128, but let me just see what I've got at 94. Fortunately, my bundle is now being unresponsive, so we may have a little delay.
Certainly, Your Honour. May I suggest perhaps...
I've got it at 128, so perhaps if you just take me to the clauses of it, it might save time.
Certainly, Your Honour, I'm happy to do that. I might also suggest perhaps somebody at the registry can assist you by sending you a PDF, because I'm working from, I just opened the link on the online portal on the e-register where they upload the bundles. And so my pages seem to be matching whatever's online. So I'm wondering whether they can send you a new PDF. But I'll proceed with my submissions on the lease agreement, because ultimately, in the meantime, we shouldn't waste time, but they are...
Yes.
We'll be going to some other documents in it.
All right.
I just mentioned that somebody might be doing it in the background while I make these submissions. But
all right.
Starting with the lease agreement, Your Honour, you'll see this was entered into on the 3rd of June 2022.
Yes.
Beginning. The first clause ultimately that I want to take you, I'm not going to take you through all of them, just whatever we rely on. But the first one is clause 16. Which is on internal page 9 of the lease agreement.
Yes.
And clause 16 outlines a number of termination occasions, a number of conditions in which a number of possible events in which one party can terminate. And the one we rely on in this case is the one at 16.3, which is on the following page, which is that the landlord shall be entitled to terminate this agreement with immediate effect by serving written notice on the tenant in the following circumstances. If the tenant fails to make any payment of the rent when due, and such failure is not cured within 3 days after receipt of notice of such non-payment. And also B, if tenant fails to make any payment of the rent when due more than 2 times in a 12-month period or more than 3 times during the term. And both of these conditions have been satisfied, and I don't understand that this is in any dispute.
Yes.
The next clause I would like to show you, Your Honour, briefly is clause 24, which is on internal page 12 of the lease agreement.
Yes.
And that is a clause that prohibits the defendant from assigning or subcontracting any of the services that provides all the space that has been leased. And that I'll come on to very briefly when we get to the name of the defendant or that issue. But I just wanted to show you that as we are here.
Yes.
Next, if Your Honor goes to Schedule 1, page 14, internal page 14.
Yes.
You see here the details of the parties, and in Part 2, you see the tenant details being given as Meshico Corporation, trading as Puerto 99 Mexican Seafood and Steak. And I'll come on to the register number is relatively important, 901857, but I'll come on to that in the course of my submissions again on the issue of the defendant's name, so to call it. And then finally, Your Honor, on the lease, I'd just like to take you to Schedule 2 on internal page 16.
Yes.
And that effectively sets out the rent that is payable.
Yes, I see.
Your Honor, it is common ground, as I said before, that the defendant has made payments to the claimant for a total of 1.281 million dirham, or 1,281,000 dirham, which consists of a security deposit payment of 350,000 dirham, a fit-out deposit payment of 25,000 dirham, and rent of 906,000 dirham. It is also common ground that no further payments have been made. And Your Honor, I want to take you now to an email, which for me is on page 138. And if my calculations are correct, your bundle is off by 34 pages. So this is probably around page 172 for Your Honor.
Yes, I've just been sent. Just bear with me for a moment.
Yes, certainly.
All right, I'm sorry. I was trying to access a link that the registry sent me, but that hasn't worked either. So I'll go back to the bundle that I had. Now, sorry, what document are you taking me to?
It is an email
Yes.
from Arvin Moraes. It's in 138 in my bundle, but I think it should be 172 or thereabouts in Your Honor's bundle. It's on the 14th of August, 2023.
All right, just bear with me. So it's an email of what date?
14th of August, 2023, from Arvin Moraes to Jacqueline Lopez. Arvin Moraes from Waldorf to Jacqueline Lopez from Meshico.
What page is it in your bundle?
138.
I'll go back there and see. Let me what section is it in the index?
It should be section E.
Section E.
Well, section E for me is exhibits, but I don't know if that's the same for Your Honor.
No, I'm sorry. I've got now. Let me just see. I'm not sure why we've got different bundles here, but I've got section A, and then section B. I have the claimant's skeleton argument, and then evidence, Waldorf case. Section C, I've got chronology, first witness statement, exhibit 1, JNM, exhibit 2, second witness statement, third witness statement. Section D.
Your Honor, I believe the parties had filed two separate case bundles. I believe the case bundle you're working off of is the first one on CMS.
Okay.
The updated bundle is the second bundle, titled Bundle for Application Hearing.
All right.
Dated.
Thank you, Ms. Alia. I'm going to try and see if I can go back to that.
Thank you.
Yes, it sounds like Your Honor was working from the defendant's bundle that was filed yesterday.
Okay. Now let's try again. Okay. Now, what page is it in your bundle, Mr.
138.
Cholikov? Sorry, 138.
Yes.
Afraid I have to wait whilst the internet brings us back to life. August 14th, 2023. I'm with you, Mr.
Yes,
Cholikov.
excellent. I'm very grateful, Your Honor.
Well, I'm grateful to Miss Alia for sorting me out.
Your Honor, this is the first email that goes from Waldorf Astoria to Meshico querying that a check. And the way that the rent payment works here is that Meshico is supposed to provide a forward-dated check, which was then presented for payment on the date that it said on its face, which was in the future, whenever it occurred. And one of these checks bounced. And so here, Waldorf Astoria is querying for the first time why the rent hasn't been paid, and that's on the 14th of August, 2023. That's just under 2 years ago. What followed afterwards over August, September, and October were constant follow-ups from Waldorf Astoria and almost radio silence at a couple of occasions from Meshico of holding responses. Until we get to their response effectively of substance of what is going on in the situation. Well, first of all, let me show you before we go to the final response. The first one is on page 132, which indicated financial problems for the first time as far as Waldorf Astoria is concerned. So on page 132.
Yes.
Jacqueline Lopez from Mexico says, I'm currently out of the country in Mexico until next Monday, management administration. I would like to address our financial situation and seek your support during these tough times.
Yes.
Which came as a little bit of a surprise to Waldorf Astoria, because if you go to the next page, 133.
Yes.
You will see that a week prior to that, Waldorf Astoria has said in the second paragraph, during our last meeting, you assured us that you had no financial challenges. And so Waldorf Astoria was not aware of any financial difficulties when that email came. And then there was no further response of any substance over the next month. So this email is on the 27th until we get to the 31st of October. And that email is on page 124.
124.
Yes, 124.
Yes, I have that.
And so that is in this email again from Meshico. That is the first longer response as to what is happening with the payment situation. And Your Honor, you see that in the effectively third and fourth paragraphs, two reasons are given. Firstly, we've been encountering significant challenges related to our restaurant's air conditioning system. The inadequate airflow has hindered our ability to promote the location effectively, which, as you know, is crucial in the competitive environment with the DFC. We've been actively working to resolve this issue, but it has been more complicated and time-consuming than we initially anticipated. And I'll turn to this is the so-called air conditioning issue in which the defendant today relies for its equitable set-off defense. But I just want to note here what is being said in the tone of it, because I'll link it to who's responsible for that, and that is, Your Honor will notice we have been actively working to resolve this. So the communication that is given to Waldorf Astoria is that third parties are working to resolve this effectively, and it has been more complicated and time-consuming than we initially anticipated. What is not said here is this is your fault, Waldorf Astoria. You have not fixed the air conditioning issue, and we've been telling you about this. And I'll explain there are four different parties, and I'll go on to that in due course. There are four separate different companies that were engaged, two on part of the building where the restaurant and hotel are located, and two on part of the defendant. They're all working towards this issue, but not the hotel itself. And so that's the context here, but I'll go on to that. Then secondly, Your Honor, you see the second reason given here is we're facing difficulties with our receivables. Unfortunately, they are currently unable to make payments to us, which has put us in a difficult financial situation. We're actively seeking solutions to this issue as well, but it has put a strain on our financial resources. And what they offer subsequently is rescheduling of the contract dates and the payment plan. But those offers are not taken up by Waldorf Astoria. And so the next significant event in the chronology is on page 143.
Yes.
And that is a notice of default being sent formally by Waldorf Astoria to the defendant, relying on the payment defaults under the lease agreement, and allowing 10 days to the defendant to pay the outstanding amount. You see this in paragraph 3. So
Yes.
this, what is this? Your failure gives rise to an event of default, and pursuant to clause 16.3, we have the right immediately to terminate, but we're giving you the opportunity to clear the balance in 10 days. No response whatsoever is received to this notice from the defendant. Waldorf Astoria gives the defendant another 2 months. Well, in fact, it's less than that. It's about 6 weeks, 5 to 6 weeks. And then we go to page 147.
Yes, I have that.
And you see an email from Waldorf Astoria to Meshico saying, "Dear all, following the below and attached email serving the notice of default letter, please find attached the notice of termination letter." I don't believe that notice is here, but it's been sent, and it's not disputed that it's been sent. We have also attempted delivering it by hand to the Puerto 99 restaurant team today, but service was not accepted. In the spirit of transparency, we would like to let you know that your access to the venue will cease as of tomorrow, Thursday, 4th of January, 2024, in the morning. And so that is said on the 3rd of January. Again, Waldorf Astoria very, very transparently sets out we're going to be basically changing the locks. Well, what happens next is an episode of egregious behavior on part of the defendant. And I think the best place to give it a context of that is the evidence put forward by Waldorf Astoria, where Mr. Muhammad describes the situation. And that's on page 23.
Yes.
So I'd like to ask you, Ron, to read paragraphs 36 to 41.
Yes.
So, Your Honor, you see under entirely false pretenses, 15 people from Mexico's part lying to Waldorf Astoria for the reason to go there just went back in. And the police was called, and rather than escalating this situation, Waldorf Astoria left them there, and they've been there ever since, and they've been operating the restaurant ever since. If I take Your Honor to what is said in the defendant's skeleton argument about this episode, that's on page 492, 492.
Yes, I have that.
And so in paragraph 4.6, what is said is re-entry allegations. The defendant denies any unlawful re-entry. Entry to the premises was peaceful, limited, and based on rights of inspection and retrieval. The first thing, it may have been peaceful to the extent that the Waldorf Astoria did not escalate into a physical altercation. It was by no means limited because they took back control of the whole restaurant. And it was based on a lie that it is to do with inspection and retrieval. But those rights are not, the right to take back your food does not give you the right to then reoccupy the property for another 2 years or so. And just to close this off, Your Honor, I just want to take you to the email correspondence to see how Meshico duped Waldorf Astoria into allowing them to do this. And I take it to, if I may, page 146.
Well, whilst I'm waiting for it to load, tell me what it is and what it says, Mr. Cholikov.
Yes, Your Honor, it's basically the response that comes to the notice of termination on the 3rd of January, where the Waldorf of Astoria said transparently that access will be revoked on the 4th of January, and the lease is terminated. The response that came back from Fadi Magdi Mekil of the Meshico group said, "Dear Mr. Ayman, hope on the 5th of January, hope this email finds you well. Based on the phone call between us today, please know that some people from the company will visit the restaurant around 2 p.m. to take food from the restaurant so that no damage occurs to the food inside." So that is the false pretenses. Thanks for your support and help, to which the Waldorf of Astoria entirely generously responds, "Dear Fadi, this is to confirm that the Puerto 1919 can come and collect the food items today from the venue at 2 p.m. And so instead of the team coming in, the 15 people engaged in what I describe as an act of thuggery, changed back the locks and effectively refused to leave, and have been ever since. They've been there ever since. And so I don't know if Your Honor has seen these emails, but perhaps you do not need to, but that's ultimately, I've read them out to Your Honor. And so ultimately, where we are today is that since the 5th of January, since this episode, the defendant has remained in occupation property, has been operating this restaurant. It has made no further payments at all of rent, not a single dirham. And therefore, at the time of filing this skeleton argument, the rent that has accumulated without any interest payable thereunder, which accrues at 5% under the lease. Currently, the outstanding rent is 3.5 million dirham, or around $1 million US.
Sorry, that's the rent until when?
Until today, until my skeleton argument last week.
I'm not sure. Can you just explain to me how that works? Your case is it not, that you terminated the lease?
Yes.
Well, after termination of the lease, how is rent payable?
Well, Your Honor makes a good point. Ultimately, it wouldn't be if they had left the property, given that they're still in occupation, and they say that the
well, you might have some claim for occupation rent or damages or something, but you don't have a claim for rent under the lease, do you?
I accept that, Your Honor. I suppose my submission was that if the lease had continued, given that they're in occupation,
yes,
that's what would have accrued. It would have been about $1 million. But I absolutely accept, and I should have said at the outset that the current claim, as it is brought, does not seek any damages or any rent arrears, or it seeks possession. And so I think I fully accept Your Honor's comment that yes, I mean, as far as we're concerned, lease terminated on the 5th of January, they should have moved out, and that's whatever's outstanding at that point, or the 3rd of January rather. That's what's outstanding under the lease. As Your Honor said, there may be a further claim for the unlawful occupation since then, and interest on the arrears. But I want, part of the reason why I wanted to have that figure on board is because when we get to equitable set-off and the case that is suggested there, I will say that my submission will be that whatever damages are incurred and they're not at all properly set up, cannot be more than the rent that would have accrued. But we'll get to that. We'll get to that in due course.
All right.
Your Honor, this is the factual background. That's all that I wanted to take you through in terms of factual background. Unless Your Honor has any questions, I'll move on to my legal submissions.
Yes, please.
And Your Honor, I should have checked at the outset, and I apologize for not doing so, but my skeleton argument, I don't know if you've had a chance to look at that, but that's on page, just to give you the reference, it starts on page, I beg your pardon, 1 second. 230 of this bundle.
Yes.
But I will take you through all the submissions there, but I just want to make sure that you've got that reference. And so, Your Honor, my first submission, as I outlined in the beginning, is that there is no equitable set-off allowed under the DSC leasing law. And the starting position...
Just to clear one matter up, the lease doesn't contain a no set-off clause, does it?
It does not.
No. Okay.
So, Your Honor, the starting position is the law on the application of civil and commercial laws in the DSC, with which I'm sure Your Honor will be familiar. But effectively,
well, it's relatively new.
It's relatively new. It's relatively new, but it's a long, ongoing issue about the incorporation of common law principles that has finally been, well, I say settled, and finally, which are not perhaps the best terms to describe it, but has now been codified under Article 8A of that law, and sub-articles 3 and 4, and that's on page 251.
Yes.
Sub-articles 3 and 4 state that in 3, the common law, including the principles and rules of equity, supplements the DSC statute, except to the extent modified by this law or any other DSC law. The DSC courts, in determining the common law for the DSC, in any case may have regard to the common law of England and Wales and other common law jurisdictions. But importantly, in my submission, Article 4 also sets out that the common law of the DSC, including the principles and rules of equity, as determined by the DSC courts, must not be inconsistent with DSC statute. And so ultimately, the point is that the DSC statute prevails over any principles of equity, and they should not be incorporated where inconsistent.
Yes.
So I rely specifically on that in terms of for this case. If I take Your Honor now to the DSC leasing law, that starts on page 325.
Yes, I have it.
And if you go to page 328, just to take Your Honor briefly through the application of the law, Article 3 sets out that this law applies to all leases, well, to leases within the jurisdiction of the DSC, and accepts in sub-article 2 lease premises that are used primarily for service departments or hotel inventory. But the hotel inventory doesn't mean restaurants and leases. It means hotel rooms. So that's what's meant here. And so ultimately the point is simply that the leasing law applies to this lease because first of all it's governed by the DFC within the contract, but secondly it's inside the DFC. It's in the Bourse de Man located within the DFC. Your Honor, we then go to page 341, still within the leasing law.
Yes.
This part sets out the provisions within the law about termination of leases. And Article 51, on which I rely, states, despite any law to the contrary, a lease does not terminate and must not be terminated except in accordance with this part. And so my reliance on this is that the intention behind those provisions is that there's supposed to be a complete code on how you terminate a lease governed by this act within the DFC, governed by the leasing law. And if you look at Article 53, that sets out the provisions for termination without a court order, which is what happened here. And you see listed in A through F the different grounds upon which a lease can be terminated without a court order. Subarticle A is in accordance with Article 55(4 of the Real Property Law, and I'll take you to that. However, what we are relying on here is actually Subarticle C. A party having exercised his rights to terminate the lease in accordance with the terms set out in the lease. So Article 55(4 is the implied power, but we are relying here on the express power granted by the lease itself. Your Honor, if I now take you to Article 55(4 of the Real Property Law, the reason why I want to do that is to contrast how the Real Property Law works as opposed to how the leasing law works, and why in the Real Property Law there is scope for the defense of equitable set-off in my submission, while in the leasing law there isn't. Although I don't need to, for the purpose of this hearing, quite have to decide. Well, I don't quite need to go to whether 55(4 does allow equitable set-off, but there is an interpretation contrast that I want to rely on between the two acts. And so the relevant provision is 55. The relevant provision is on page 275.
Yes.
And you see 55 gives implied powers of lessors and termination for breach. And that in my submission is in cases where those powers do not arise on the terms of a lease within the DIFC, as the leasing law provides. And so that's one of the options. And you see in 55(4, that's the power to terminate when rent is due more than 30 days, and when there's been a demand that's not been remedied. But importantly, Your Honor, I want to draw your attention to Subarticle 7. This article is subject to any law imposing restrictions on a lessor's right to recover possession from lessees. So in my submission, that, for example, could allow for an argument that there is scope for equitable set-off as a right to recover possession from a lessee, but that is only when one relies on Article 55 of the Real Property Law. There is no equivalent provision in Article 53 of the leasing law. And
so in sub-article 7, the reference to any law is wider than any statute law, is it? It's not referring only to written laws of the DIFC.
Potentially. For the purposes of today,
Yes.
I don't think this question needs to be resolved, but I think potentially, I think that there is here scope for the argument that any law means also equitable principles and the principles of equity. But in the leasing law, the article particularly that I rely on is 51, which has the opposite language. We go back there just very briefly. So this says subject to any law. In 341, on page 341, Article 51 says the opposite, it says despite any law to the contrary.
But in terms, 51 says a lease does not terminate and must not be terminated except in accordance with this part.
Yes.
What it is appears to be limiting is the right to terminate.
Yes.
Which perhaps may not extend to some defences or matters which give the tenant the right to resist termination.
Well,
yes.
Your Honour, the basis for termination here is non-payment of rent, and the basis of equitable set-off is not. So the challenge to that, to possession, is effectively a challenge to our right to terminate. Because of course, if we did have a valid right to terminate, then we'll have no grounds of possession. So possession arises only from termination. So equitable set-off goes to the basis upon which we rely for termination. And so in my submission, the difference there is that because of the operation of Article 53, what that really is trying to do is to allow the parties to set out the contractual basis upon which termination occurs in 53C. And therefore, if you are relying on that contractual basis and the parties as commercial parties within the DFC have agreed the principles upon which a lease terminates, then that is the end of the matter in my submission according to this law. There are no other equitable set of defenses. But you see, Your Honour, in a situation where the parties have not agreed those provisions and the landlord has to rely on 53A, which is the reference to the real property law, and that's the implied power. Then, in case of the landlord relying on an implied power, then in my submission, the law does potentially open the door to equitable set-off. And I believe that makes perfect sense, because ultimately, when the parties have agreed the contractual principles, in my submission, what this law does is to give effect to that agreement contractually. But when there is a lacuna, when there is a gap in the contractual agreement, then all of the principles otherwise available would apply, including defences. So that essentially is my case on the interpretation.
How does set-off work in this context, in that your right to terminate arises from rent? Perhaps I need to go back to the lease, but is it rent due and owing, not being paid? And if there's a right of set-off, is the rent due and owing? Perhaps it is.
It remains due and owing. The question is whether the set-off outweighs the rent payment. And so ultimately, if there is, the theory behind it is if our breach, if the alleged breach arising under the air conditioning issue has resulted in damages that are greater than the rent outstanding, then the defensive set-off operates to say you actually terminated without any basis for doing so, because the damages that are due to the tenant are bigger than the rent outstanding to the landlord. So
do you accept, Mr. Cholikov, that if the defendant has a right of set-off, then the rent I'll start that again. Take a bit at a time. Do you accept that if the defendant has a right of set-off, and if the damages which the defendant is entitled to set off equals or exceeds the rent, then there's no rent due and owing, no default, and you were not entitled to terminate?
No, Your Honor.
No,
and I'll explain, go on to the cases now on my alternative reason why there is a second element to
Right.
the equitable set of considerations.
Yes.
I mean, that what you described, Your Honor, is the first element, but there is
Yes.
also the equitable element of that. And so
But you accept that the first element would be satisfied if those assumptions were made good.
it's subject to one other point, which
Yes.
is, let me perhaps take you to those elements, and then I could perhaps address you again on that question.
All right.
Because it's not, I do not accept it straightforwardly. It's subject because there are some other considerations. But so if we go to the so basically my alternative case, if the setup is available under the statute, why it shouldn't be applied. And so first, to take it to the relevant tests. And so I'm going to look at the tests in the DFC very briefly, because there's only one case that I've been able to find on this point. And then I'm going to look at the position in Australia and then position in England and Wales.
Okay.
The first case that I want to take you on to is on page 487.
Yes.
And that is the Industrial Group Limited and Abdelaziz El Fadil Hamid. Interestingly, this is part of the same saga that brought about Article 8A, but that's a different facet of that saga. On page 488, this is a very, very short order with reasons by Sir Justice Richard Field. Sir Justice Richard. That presumably, I may be wrong, it might not be Richard Field. But in any event, article paragraph 5, the justice sets out the following: the claims which are made in the expert's report are properly characterized as a counterclaim. They do not, in my judgment, amount to defense. For there to be a defense by way of a cross-claim, the cross-claim must amount to what the law calls set-off, and there can only be set-off where there is a very close relationship, and I draw your Honour's attention to the words "very close relationship," and I'll say why in terms of how this fits in with the English and Australian approaches, between A's claim against B and B's claim against A. In my judgment, there's no sufficient relation between the claim made by the claim for payments, which have been received and improperly indented for, and the claims which are identified in the expert's report. And so the considerations. So this is the first element, and I'll turn to the Australian and English tests, and they make that out more clearly. But that is effectively the first element of the consideration. Although it's not quite a two-step approach, as it is said, but that's the first thing, whether there is a close connection or close relationship between the claim and the counterclaim. And so it's not in every case where, for example, as Your Honour asked me earlier, A has a rent outstanding against B, B has damages against A, they're automatically go together. It's not necessarily the case. It's a factual exercise on each case. But if we now go to firstly the Australian approach, and the reason for that is that the Australian approach is based on the previous English approach. So chronologically, it's what came first. So that approach effectively follows Lord Denning's judgment in a case called the Namfree. But I'll make my submissions by reference to the key authority on this in England, which sets out also the previous approach. And that starts on page 455. Your Honour, this is the case Geldof, Metal, Constructi, and Simon Cowles, English Court of Appeal judgment. Does Your Honour have that?
I do.
Yeah,
yes, I do.
And so I want to take you first to page 465. And you see here, the Court of Appeal sets out the previous approach from B to E. The non-frivolous importance is that it was on occasion of further consideration of doctrine of equitable set-off, and Lord Denning sets it out. I mean, the non-free is not the original case that sets it out, but it is a case that exemplifies, I mean, shortly summarizes in Lord Denning's usually memorable ways what the principle is about. And from if Your Honor reads from D to E, that is effectively what remains the approach in Australia. But one thing is clear: it is not every cross-claim which can be deducted. It is only cross-claims that arise out of the same transaction or are closely connected with it. And it is only cross-claims which go directly to impeach the plaintiff's demands. That is so closely connected with his demands that it would be manifestly unjust to allow him to enforce payment without taking into account the cross-claim. And so that, Your Honor, the manifest injustice is the second element of the equitable exercise. So ultimately, that is the further consideration, and that is set out even more clearly in the rest of this judgment, because the so-called modern English approach, which is set out in this judgment, so that's the key authority currently in England, starts on page 472. And so Lord Justice Ricks summarizes in paragraph 43 the conclusions of the jurisprudence and where the position is. And so, Your Honor, ultimately, this is the key paragraph. I particularly rely on certain bits of it, but ultimately, the 43.2 is the first element. And so the Court of Appeal refers to them as a formal requirement and a functional requirement. And so the formal is set out in subparagraph 2. There is clearly a formal requirement of close connection. It's not also been discussed in the DIFC case, which was called, where it was a very close connection. So there's a slight difference there. Whereas the English and Australian approaches require a close connection. But if I take you importantly to the subparagraph 4, which is at the bottom of page 473, and if I ask you, Your Honor, to read 4 and 5 in their entirety, sub 4 and sub 5.
Yes.
And so in particular, Your Honor, rely on the following propositions, which are, and I read them out. There is also clearly a functional element whereby it needs to be unjust to enforce the claim without taking into account the cross-claim. It is not coherent to have a doctrine of equitable set-off, which ignores the need for consideration of aspects of justice and fairness. And then finally, the summary of the approach in England, the importance of the formal element is to ensure that the doctrine of equitable set-off is based on principle and not discretion. But the importance of the functional element is to remind litigants and the courts that the ultimate rationality of the regime is equity. And so, Your Honor, turning now to my submissions, and I'll suggest that whichever approach this court chooses to follow, whether the English approach or the Australian approach, the outcome in this case is the same. As I said, the DFC case requires very close connection. I'm not sure how much the court can or should read into the emphasis of very, but ultimately there needs to be sufficient proximity. And I will make my submissions in sort of those terms: the functional and the functional, the formal and functional element. And so turning first to the formal element, to that close connection of proximity between the claim and the cross claims. I say for three reasons there isn't such a connection. And so the answer to Your Honour's question is no. On our facts, I do not accept that even that requirement is satisfied by Meshico on the air conditioning issue. And here's why. First of all, in this particular case, Waldorf Astoria brings only a possession action and not any rent arrears claim or claim for damages or claim for late payment and any interest. And so properly, any damages that would arise as a result should be set off against the rent payable and not against the contractual right to termination that has arisen already. And that, I think, I am assisted in that respect by the DSC authority that requires a very close connection, and the consideration is not simply payment of that sum to payment of the other sum. But secondly, Your Honour, and alluded to this already, fixing the air conditioning issue was not the claimant's responsibility. There were 4 other parties that entirely separately from the claimant were working to fix that issue. And I want to take Your Honour to the factual side of that.
Just before you
Yes.
do that, the way you put that was who was working to fix it. That doesn't necessarily mean those were the parties responsible for it.
Indeed, I accept that. In my submission, they were both responsible, and because they were responsible working to fix it. But I suppose I have 2 alternatives to this argument. And the first is that Waldorf Astoria was not at all responsible. But if Your Honour is not prepared to make
that depends on the terms of the lease, doesn't it?
Yes, and I'll take you to those.
All right.
But if Your Honour is not prepared at this summary stage to make that conclusion, then my alternative argument to that is, as far as the defence of equitable set-off is concerned and the close proximity of the case is concerned, the reason why the defence of set-off should not be allowed here is because any action on deciding this issue necessarily needs to involve the other 4 parties and their respective responsibilities in the same proceedings, because ultimately, and I'll show you in the facts of the evidence, it is very clear that they had responsibility to do that. But let me perhaps take you first to the provisions. And so if we start on page 51,
Yes.
this is part of the claimant's evidence. And
Yeah.
if I ask Your Honour to read paragraphs 18 and 19 first.
So the hotel is owned by the Bergdemann principal body corporate.
So the building, so the way it works, basically, Your Honour, it's a very big building. It's a skyscraper in the DRC, and that is a mixed-use building. So that's the Bergdemann. That has in it offices, it has residential properties, so flats in which people live. It has the Waldorf Astoria hotel as well in one part of the building, and so the Burj Demand Principal Body Corporate is established to manage all of this. So that's effectively the association that manages the entire building.
Mm-hmm.
And I can take you perhaps to this is to just show you.
So the claimant, or just start a bit of time, does the claimant own the building?
The claimant owns, no, it owns only the DSC hotel within the building, not the whole building.
But
That's
it owns it owns that part of the building.
Yes, that's my understanding. I don't know if
it doesn't merely lease them from the owner.
Well, that I'm not sure. I know the answer whether it's a long leasehold or it's a freehold. Effectively, that as we will put it in DSC terms.
Because
but I believe
the lease. I think the lease says that it owns the premises which it's leasing, doesn't it?
It does. It definitely owns them. I don't know if there's any time limitation to how it owns them in the DSC, but it is definitely the owner, and that's in the lease and also in the evidence. So it owns that section of the building, but that's within the bigger buildings, in the same way that somebody would own an apartment within that building. And actually, my client, the claimant, doesn't operate the hotel. It is exactly as Your Honor described it. The owner, the operator is Hilton. So it's a separate business. And so, but maybe if I just briefly take you just to show you the establishment certificate of the body corporate, that's on 225.
Yes.
And so just to show you, that's basically the association that acts on behalf of the body corporate, so on behalf of everybody in that building. That includes Waldorf, it includes all the businesses, all the residents, and it has a management agreement by which it manages all the utilities and everything to do with the building. And that is the basic setup of, because ultimately, Your Honor, this building, the air conditioning to this building, the pipes.
Well, is this the way it works, Mr. Cholikov? The building is subject to, I haven't looked this up, but it appears to be it's under the strata title law, so that different parties own different parts of the building, and the body corporate is responsible for the common parts of the building.
That's right.
Okay.
That's right. And there may be, and we'll get to that, there may be a dispute. In my submission, it's clearly the body corporate's responsibility for that. The defendant might say, no, actually, this is not the common parts. It's part of, I imagine, will be said against me, but I'll address you on that and on the facts as well. But ultimately, yes, that's exactly how it works. And the entity, so the body corporate being the manager of all this, appointed a specific company to manage the utilities. And if we go back to the claimant's evidence on that, we're back to page 51. In paragraph 19, Your Honor will see that it's the members of the body corporate are elected by the owners under the Strata law, and the body corporate appointed Logic Utilities to provide consultancy and cooling services for the occupiers of the building. So they appointed this other company to manage those services. In terms of the relevant part of the lease, paragraph 21 sets out the relevant provision.
And remind me where I find the lease.
Yes. The lease starts on page 94.
And you're going to which clause?
I am going to paragraph 1.4 of part 1 of schedule 2. So I was going to do it by reference to the evidence, but Your Honor rightly goes to the lease itself. So it's on page 110. This is schedule 2, part 1, paragraph 1.4. And so, but what it said here is the part is. I mean, I'll let Your Honor read that subparagraph, which provides what is part of the responsibility of Waldorf.
Yes, and what's the relevant area?
The relevant area is volume 5. This is what the what Meshico occupies.
Right.
That's what's been leased.
So clause 1.4 is referring to what makes up the charges that make up the rent. And it says the rent does not include utilities used within the area leased by the defendant, such as water and chilled water. So the rent payment doesn't include utilities used in the area.
Yes.
All right.
Um,
But that doesn't say anything about whether or not the landlord claimant is responsible for providing water to the area, does it?
not directly. Not directly. And in my submission, there isn't a direct such obligation. I mean, what
Right.
we're saying by reference to this is that the rent is not paid and therefore there's no obligation. I mean, Your Honor, while we're on the lease, will see that services to be provided, if you go to clause 13, which is on page 102.
Yes.
It says services to be provided by landlord to tenant and tenant's obligation to the services described in part 3 of schedule 2, which is blank. And so if we go back to part 3 of schedule 2, which is on page 110.
Yes.
That there's nothing there. There are 3 exhibits of covenants that follow, and that they basically are separate, but they describe the relevant area, which you can see on page 111. And there's some photos in the evening of the restaurant.
So you're saying the lease does not provide any obligation on the landlord to provide any services?
Yes, other than effectively what is said in 1.4. Waste management, maintenance of. I think it's not directly, but I think I can't really argue against the mission that if the parties have agreed and acknowledged
Yes.
these services to be provided in the rent payable by the tenant, then obviously that the landlord needs to provide them. I think I will struggle to argue against an implied term to that effect.
Yes.
But there isn't in my submission, and I have not found a direct express obligation on this paragraph 1.4 that requires the landlord to be dealing with this AC issue. And as I just outlined, Your Honor, I think the good reason for that is that it's just not within the hotel's ability to do that, and it's managed by the Strata and Logic Utilities. And if I take you now to
but the body corporate standards and its manager owns and manages the common areas, not the area within the not the area which is owned by the landlord and not the area which the landlord leases to the tenant.
That's right, but it operates all of the AC in the building and the piping and all of that is central in some way for everybody. It's not as if the hotel has its own plumbing that is disconnected from the rest. From my understanding, I don't want to go into technical evidence. That is, there's so much that I think this hearing can be achieved in that question. But I think in terms of responsibility, what is very clear is who is responsible for managing what the defendant wants to do on the evidence.
I'm just trying to envisage how it all works, Mr. Cholikov.
Yes.
I suppose within the tenanted area, there will be pipes and ducts out of which comes the cooling air.
Yes.
And they must then be connected to other pipes.
Yes.
Leading to the plant, which is probably part of the common area.
Yes, and so yeah, absolutely. And so the question is who manages those pipes? And because what the defendant is saying is there wasn't enough chilled water going in the pipes to us, and therefore the AC wasn't working. And I put that case no higher, and that's what's alleged. In terms of the practical impacts and consequences that follow, that's a different story. But in terms of the technical issue, I think that's what's alleged. But if I just take Your Honor to how
just on that, as you understand it, what is alleged is that the flow of chilled water into the pipes, which, well, no, I'm not sure I do understand it actually, because I'm not sure how the air conditioning works, whether what comes into the tenanted area, it would seem, must be some chilled water, which then somehow produces a flow of cooled air. I'm not quite sure how that works, but
yes, I think so. And the question is how that chilled water can be increased or decreased. And if the volume, and maybe if I take you to the actual issues, you'll become clear. It might not. But if I take you first to page 30, which is the defendant's evidence.
Yes.
On paragraph 29, you'll see the defendant says, as part of the fit-out works, the defendant has engaged Design Infinity LLC as the main contractor and DHA Technology SZCO as the MEP contractor. And then you see in paragraph 30, Strata Global, this is all the defendant's evidence. Strata Global was the managing company of the claimant, and Logic Utilities was the agent handling all of the claimant's utilities, including the air conditioner. So the defendant accepts that that is the party. This is the defendant's own evidence that Logic was the party responsible for managing the claimant's utilities, including the AC. And so in practical terms, Your Honor, if I take you, for example, to page 176, this is an email. I don't know if Your Honor has it.
I'm still waiting for it to load.
Right.
Yes, I have that.
176 is an email that is coming from Design Infinity, which is appointed by the defendant. And it is addressed, you see, Dear Thayu and Rohan. Request your kind support in sorting out the chilled water issue as we can't move forward with the ceiling grid works and other related works due to this parallelly affecting the project timeline. So Thayu and Rohan, Your Honor can see who those people are. So in the 2 line, you see it says Thayu Manavan, that's Strata Global, that's Thayu. And in the CC, 2 lines from the bottom, you see Rohan at Logic Utilities. And so what is not said here is, Dear Waldorf Astoria, can we have more chilled water? What is said here, and it's constantly been said, is Strata and Logic Utilities, which the defendant on its own evidence accepts, is the entity, is the company that is responsible for managing the claimant's AC, are the people who...
Yes, I don't know that really follows, Mr. Cholikov. What this shows is that the fit-out contractor was, as a practical matter, contacting Strata Global and Logic Utilities as the people to provide assistance in sorting out the chilled water issue.
Yes.
I don't think anybody there is addressing who has the legal responsibility to provide chilled water.
No, except that you're
and
wrong.
And even if they were, it would only be an opinion.
Yeah, I accept that. But you know, for the purposes of just pulling this all back to where we are today in today's hearing, I mean, this all fits into the close connection test, the close connection element of the equitable setup. And so the extent of my submission is not that Your Honor needs to today decide whose responsibility it was. I mean, I showed Your Honor my submission on legally that it was not in accordance with the lease Waldorf's responsibility. I've also shown Your Honor practically that Waldorf was not involved with that. But I don't think Your Honor needs to decide this question today to dismiss the defense of equitable setup. All I'm submitting here is that because of these complex other entities in which are involved with this situation and potentially need to be drawn in as parties to any question on who is responsible for the AC issue, that goes against a simple, straightforward, close connection test under the lease agreement, where one might imagine, for example, a simple landlord and tenant saying, you didn't fix my boiler, and therefore I'm not going to pay rent. This is the more complex situation, and it would not be within the close proximity to allow the tenant to stay in possession of this property for years to come, while this litigation between multiple other parties and the landlord and tenant is resolved, if it ever proceeds to that, because I'll go on to in the second consideration why it doesn't seem as if the defendant has any real intention to proceed with that. But in my submission, the right place to do that would be in, and that is why Waldorf Astoria has not brought a claim for damages in rent arrears. The right place for that will be that claim. And my instructions are that Waldorf does have every intention to pursue that action. And if a counterclaim to that action is brought along those terms, then Waldorf will accept it. And it can, all of this can be resolved there. But in the meantime, Waldorf needs to get its property back.
All right. And
is the
whilst
main
I'm
point.
on that issue, Mr. Cholikoff, you put
Yes.
you put it that the claimant's right to terminate came from a rent default followed by notice in accordance with the lease terms. What actually happened then was, or was it, the landlord re-entered and took possession of the premises. Would that have terminated the lease in any event?
Yes.
Even if
yeah.
do you have a right of, well, two questions, I suppose. One, in the absence of a rent default and notice, did you have a right to re-enter? Secondly, even if you didn't have a right to re-enter, but you did re-enter and take possession, did that terminate the lease in any event?
I believe it did. Yeah, Your Honor, I think that's right. Ultimately, the rights of termination and re-entry, there are multiple breaches. I mean, for the purposes of today's hearing, what is only relied upon is the rent payment. And that is why I focus my submissions on the rent arrears. But for example, if you there are on the re-entry issue, you can see, I'm just trying to find. Well, first of all, let me take you to page 103.
So 103?
Yes.
Still waiting for it to load, I'm afraid,
Yes.
Mr. Cholikoff.
I will wait this.
So what's at 103? Yes, I have it.
103, and then I'll take you to the re-entry point that's in the law. But on 103, I just want to show you in clause 16.4, the landlord may terminate this agreement in accordance with part 6 of schedule 1. And while we're here, we've got 16.5. Those are the obligations of termination that the tenant was supposed to follow.
Yes.
But if we go to the relevant part of the schedule, that's on 108.
So does that mean that the landlord can terminate without default on the part of the tenant?
It does. But that's that's not what's being relied upon. But yes, my submission very clearly does. But here we are, and in terms of Your Honour's question on right to re-entry, that is not contractual, but it is in the law. And if I take you back to Article 55 of the Real Property Law, which is, or 55.4, which is what is also incorporating the leasing law as one of the limbs, but it's not the limb on which, well, in theory, both can be relied upon, but the contractual limit is what specifically in this case I'm relying on, but for the equitable setup analysis. But if you go to 55.4, which is on page 275,
Yes.
55.4 grants an implied power to re-enter and terminate on the non-payment of rent. And so, pursuant to the law, I agree, Your Honour, that the lease terminated as on the 3rd or 4th of January, whenever at the latest. In my submission, terminated contractually on the 3rd of January. It terminated then by law on the 4th of January when the tenant re-entered. And so currently, effectively, the defendant is trespassing. Is the analysis of what is the present situation in reality. And so the reason why they're trespassing is because of that episode. We wouldn't be here, but for that episode of what I describe as thuggery, when they came back in and changed the locks with 15 people. I mean, what would have happened but for that episode is that Waldorf would have had possession back of its premises. It would have had rent arrears outstanding, and there would have been separate litigation specifically on this air conditioning issue. As in my submission, that is the right way to go about this. And if it is true that the defendant has suffered these damages, as it alleges, then all of this can be brought in there. Way of counterclaim, technically, it can be brought in a separate standalone action as a breach of the lease. And then all of the damages can arise if for example, Waldorf doesn't pursue, although I'm instructed it will, the defendant can't pursue Waldorf independently after all these damages. But that's nothing to do with possession of property. And it can still recover these losses that way.
All right.
And so that, just going back to on the point of the losses that are alleged, Your Honour, if I take you to the defendant's evidence, that is on page 38.
$38, did you say?
Yes. Yeah.
Yes.
Paragraph 88. So what is said here is that the defendant has sustained losses as a result of the poor AC in some absolutely astonishing magnitude. It says it expected to generate between 2 and 2.4 million dirham a month, but it says as a result of the air conditioning issue, it is achieved only 20 to 24 times less, which is 100,000 dirham per month. In my submission, these are staggering numbers that the court can't simply accept on face value. And the reason why it can't, and it shouldn't, is because there should have been evidence here, and I raised this in my skeleton argument. And obviously the defendant has been filing papers yesterday, but none of those, and the defendant has had my skeleton argument since Tuesday last. And I raised this in my skeleton argument, paragraph 45.3, which is on page 15. Oh, I'm sorry, that's the wrong reference. The right reference is in fact page 244. And Your Honor, you see that in paragraph 45.2, I set out that exact paragraph from the defendant's evidence. And then in paragraph 45.3, I take a number of points against it for the lack of any substantiation in evidence to support these numbers that would have been obviously and readily available and should have been put forward if the court is to take this to have any value, any real substance. I mean, first of all, the defendant could have easily put forward its available business plan for what it was imagining it would generate by way of revenue. Secondly, it would have put forward what it actually achieved by way of revenue, its accounts, profits and losses. And internal communications, for example, of how an analysis of how that is impacting the issue. For example, it could have produced data of how many customers it had, how many customers it expected, because air conditioning, they missed their targets. And then in my submission, Your Honor, that could have resembled a case on losses. What we have here is a number plucked out of thin air with no support behind it and no evidence to suggest that. I mean, if this is not at all a proper, sufficient, evidenced allegation that a court should accept to give rise to equitable set. The defendant can't just make up a number and say these are
just a minute, please. Just a minute, please, Mr. Cholikov. Dr. Makeda. I just wanted to make sure you were still with us. Thank you. Yes, carry on, Mr. Cholikov.
Yes, so that is my point of losses. I mean, the court should give no weight to that mere suggestion when there's obvious, readily available evidence that should have been produced back in the application. But in any event, I have taken these points in the skeleton argument. They've been unnoticed for a week, and evidence has been filed as late as yesterday, and that doesn't address those points. And Your Honor, now turning to the equitable functional element of this is all by way of the close connection. And so, I mean, I say this, obviously the losses goes to both elements in my submission, but I set it out in a close connection because there is no close connection between a clear, proper, substantiated claim for rent in a certain amount and a number plucked out of thin air to defeat, for sole purposes, to defeat that otherwise proper claim for rent arrears without any further support. But in terms of the equitable element, I would suggest that there are many reasons in that functional element why equity should not come to aid the defendant. Now, first of all, the defendant for 2 years has been in possession of that property, having forcibly and under false pretenses re-entered it. Secondly, in my submission, the air conditioning is either an artificial reason or at its highest is not the only reason why the defendant is suffering difficulties for two reasons. First of all, we saw emails from the defendant specifically talking about problems with its receivables. So financial difficulties resulting from its receivables.
What does that mean in the context of this is a restaurant, isn't it? Are its receivables just what the patrons pay each time they come, or would there be, or is there some sort of corporate setup that just not sure what receivables means in this context?
I have no idea, Your Honor. If the counsel put forward before the court, maybe we could have had an answer. But I mean, my understanding is this is an incredibly complicated and oblique corporate structure that operated a number of, and I'll go on to that at the end of my submissions, that operated, right. And I'm telling you that a number of restaurants in Dubai, every single one of which has shut down except this one. And that is explained in paragraph on page that's on page 18. If I take Your Honor there.
Yes, please.
Page 18, paragraph 10.
Yes.
So this is the claimant's evidence. This is not something that's been refuted. So it's not disputed. In paragraph 10, the claimant says, the respondent Meshico is the owner and operator of Puerto 99 restaurant brand in Dubai. It is part of the Meshico Group, a UAE-based conglomerate operating businesses across food and beverage, retail, and real estate sectors. It has had other restaurants in the UAE and elsewhere. However, shortly after the claimant terminated the lease agreement with Meshico in January 2024, on which see paragraph 35, we've been there already, I was informed by a member of Meshico's public relations team that its remaining restaurants in the UAE located in Blue Waters, Dubai, Dubai Mall, Dubai Hills, and Dubai Hills Mall were all experiencing financial difficulties. Before I subsequently discovered in March 2024 that they had in fact all closed down. And so for the past year, the only restaurant that is operating is supposedly the one restaurant that has significant air conditioning issues and nobody wants to visit. But all the other restaurants have shut down. In my submission, that heavily goes against the weight that should be placed on this air conditioning issue generally as to the financial situation of the defendant. The next point that I'd like to make is the defendant appears in person today, but the defendant was represented until very recently. And it was represented by a law firm called BSA Law, and that law firm asked to go off the record because it said, I quote, and that's in evidence before the court that was filed by the law firm. It said there is no realistic prospect that BSA will be paid its professional fees for representing the defendant. And so in my submission, there's also no realistic, effectively, either the defendant doesn't have the means to properly pursue the air conditioning issue, in which case, Your Honor, are you still here? There was a bit of blurriness, and I just want to make sure that...
Yes, no, yeah. I'm with you.
Great, thank you. Either the defendant doesn't have the financial ability, as is presumably said here, to pursue the counterclaim, in which case there are serious questions about the solvency of the defendant. And the defendant is insolvent, and that's a separate breach under the lease that would allow re-entry immediately. Or the defendant doesn't have the desire to do that, and doesn't want to spend any resources on doing that, in which case what he simply wants to do is prolong its free occupation of the property while it's running the restaurant, because it's not, Waldorf is not being given possession of it, and that's continued now for 2 years. And the final point that I'm going to make, and I've been alluding to this in all my submissions, is who is the real party here? We were told, I mean, obviously, if I take Your Honor to the lease, which is the lease that was signed, on page 107, the name of the legal entity there is Meshico Corporation in part 2. Meshico Corporation trading as Puerto 99 Mexican Seafood and Steak. And if you see the registered number, it says 901857. And the other point to make here is that Meshico is a corporation. So that is the form of entity that's being described here. We then turn to the defendant's evidence, which came as a surprise to the claimant on page 28.
Yes.
Paragraphs 12 to 14, the defendant says, I accept the lease agreement was between the claimant Meshico, the claimant Waldorf or Ward Holdings, and the defendant Meshico as named. However, the lease itself was registered against Puerto 99 Bar and Restaurant and Bar Limited, and I exhibit the FC Property Tenancy Information Registration Certificate. Even though the name is wrong, the correct tenant is and has always been Puerto 99 Bar, Restaurant and Bar. But if I take you to that exhibited certificate, which is on page 175,
It's taking a little while to load, Mr. Chelikov.
yes.
Yes, I have it.
If Your Honor sees, that is the certificate on which the defendant relies. The second table sets out passport number, commercial license 6364, so that's a different number. And the name is Puerto 99 Restaurant and Bar Limited. And so limited suggests that that's a limited company, which is a different form of entity from the corporation. And so what I'm reading between the lines here is that first of all, I don't accept that it's the same entity, and I don't accept the defendant's evidence that there's simply been a name change. In my submission, it is more likely that we're talking here about two different entities. One is a corporation, the other one's a limited company, potentially registered in different jurisdictions within the UAE. But in addition to that, I think that the reason why it comes into the analysis on the functional element of equitable set-off is that the real and tangible risk that faces the claimant in these proceedings is that if it does not take possession of its property, and also to an extent, even if it does, but the losses will be more limited, it is very likely, given particularly the financial difficulties that the defendant has put front and center, not only in correspondence, but is also unable to pay its legal representatives, it's very likely that protracted litigation, even if won by the claimant, is going to result in pursuing insolvent entities, and those losses will never be recovered. And so not only is the claimant very likely to never recover any rent, it's also very likely to never recover any further damages for the unlawful occupation of the property over the past 2 years. But if it doesn't get its property back today, it's also unlikely to recover any losses going forward, because, I mean, all of the evidence suggests, first of all, it's not clear which is the right entity. Secondly, the defendant he has been relying on the fact that he has significant financial difficulties.
So what is your case, or what do you say the evidence shows about the different entities? Is Puerto 99 Restaurant and Bar Limited a different entity from the defendant? Is it the same entity who's simply changed its name, or do we not know?
We don't know, Your Honor. I mean, the defendant says it's the same entity has changed its name. In the skeleton argument on page 492,
492, yes.
Paragraph 4.5, it says the entity Meshico Corporation trading as Puerto 99 was renamed but retained operational continuity and managerial control. Again, that's simply asserted. One would expect that if the defendant wanted to substantiate that assertion, it would have been the easiest thing and file and then put forward the renaming certificate. So we don't know the answer.
Your case, I go back to your claim. The relief you seek is a declaration that the claimant has validly terminated the agreement, that the defendant is required to vacate the property. And that you're entitled to re-enter the property.
Yes,
all
Your
of that
Honor.
relief is sought against the defendant if the Puerto 99 Restaurant and Bar Ltd is a different corporate entity from the defendant. Then do you say you're still entitled to that relief, and the different company, Puerto Restaurant Bar Limited, is simply a trespasser with no right to be there?
Precisely, Your Honor. And the reason, if Your Honor, I've sort of explained.
And just to finish that,
Yep.
Mr. Cholikoff, and you say similarly, if it's the same entity which changed its name, that it doesn't matter. Yes.
Precisely. If it's true, as the defendant suggests, it's the same entity changed its name, doesn't change anything. But in order for us not to find ourselves at the door of the restaurant again, with Your Honor's order, as I submit Your Honor should give, only to be told, oh, we are not Meshico Corporation, we are a different entity. When this claim form was filed, the claimant didn't know anything about this issue. The claimant simply assumed that there's a defendant that's called what it's called on lease. But to address this, Your Honor will see this in my scale, described in my case and argument, but we tweaked the draft order, which is on page 10.
Take me to that. What is it?
Yes, so page 10.
Page 10. Yes.
And so that's where it starts. But the relevant paragraph is on page 11, where the declarations are set out.
Just excuse me a minute. Yes. Page 11, yes.
And in paragraph 2, subparagraph B, that originally, this is the amended order. What this declaration originally said is the defendant should vacate, is required to vacate the property. That now says the defendant or anyone else presently in occupation of the property, including for the avoidance of doubt, Puerto 99 Restaurant and Bar Limited, is required to vacate the property.
Well, how would I make that order if Puerto 99 Restaurant and Bar Limited is a different entity? Then I cannot make that order in the absence of any case being brought against Puerto 99 Restaurant, can I? If Puerto 99 is not a party to this case, then it would not be
I think Your Honor is entitled,
perhaps not within my power.
I think Your Honor is entitled to proceed on the case that is put forward by the defendant. I think all we're asking in the defendant's case is that it is the same entity. All I'm asking for, and perhaps you don't want to say anyone else presently in occupation. I see the reservation there.
Yes.
All I'm asking for is the bracketed language, including for the avoidance of doubt, Puerto 99 Restaurant Bar Limited, because I take it. I mean, there is perhaps a point that and that's why I took it to the lease to suggest that there is no right to sublet or subcontract or anything of that nature. In clause 24 of the lease. But I think as far as this hearing is concerned, I think Your Honor is entitled to proceed on the defendant's case on that. And just to, unless Your Honor has any other questions, just to sum up briefly my submissions.
No.
They are number one, the equitable set-off is not at all available in these circumstances in this law. But number two, even if it were, the defendant's equitable set-off has failed to satisfy both the formal and functional requirement on the English approach, or the close connection and the manifest injustice on the Australian approach, or the very close connection. But in my submission, that is not enough. I mean, that the SC authority that simply says very close connection is not enough to bring in the equitable set-off. But in all of these cases, in my submission, it fails both because of the close connection and because of the equitable element. And therefore, even if available, it should be denied. And ultimately, the claimant needs to take back its property.
All right.
Unless I can assist you any further, perhaps no. I can then come back and reply if needed.
All right. Thank you very much, Mr. Cholikov. I think, well, perhaps I'll go to Dr. Makeda. Dr. Makeda, how long... now, Dr. Makeda, it's your turn to make submissions on behalf of the defendant. Approximately how long do you think you might be in making those submissions?
I don't want to take a lot of time, Your Honor. Maybe 45 minutes maximum.
All right. Well, I think in that case, I think we'll proceed unless either of you wishes to take a break before we... No, are you able to proceed now, Dr. Makeda, without taking a break?
I am able, but it's up to Your Honor.
Yes. All right. No, I think we'll carry on. So please proceed with your submissions, Dr. Makeda.
Thank you so much. Good morning. My name is Dr. Jorge Mateo. I appear here in the court as litigant in person, in representing Meshico rotation and Puerto members. As stated by Mr. Cholikov before, sadly, by unilaterally causes our previous helping involved us as clients 2 weeks ago. That's why I went 10 days ago, so that's why I'm here working as a litigant in person. My background, I am a physician and a surgeon, so I will try to do my best. I'm not an expert in law, but I am trying to submit evidence.
Dr. Makeda, can you please do your best to speak as close as you can to your microphone? It's a little bit hard to follow you at times.
Okay, can you hear me there better?
That's better. That's better.
Okay, perfect. So, just general terms, and I will speak a little bit more into summary of all the things that we have been going through. Not as I'm not a lawyer expert, I'm not going to point out a lot of laws and all of that I am not familiar. But the claimant obviously seeks immediate judgment for not payment of rent. But this is not a straightforward rental arrears case. This centers on a lot of things behind that is critical for our working infrastructure for the restaurant, specifically about the chill water flow. As the defendant, as the claimant was stating, all these things from their end started in August, September 2023. For us, we didn't start in 2023. For us, they started in October 2022. And I will point out for the first email communication that was, and you can find it in our case bundle in section B. Is and I will just point out the email name is chill water issues since October 2022.
I'm sorry, I'm again having a little difficulty hearing you clearly. If you can just do your best to speak as closely to your microphone or clearly to microphone as you can.
Okay, can you hear me there?
I should say that I'm also struggling a little bit. So
yeah. And again, Mr. Cholikov, please, if at some stage you can't reasonably hear what's being said, let me know. So do your best, Dr. Makeda, to stick to your microphone and so that we can hear you.
Let me see if I can change to, well, maybe it's because of the wireless connection. Let me see if I can change to this.
I think what we might do, Dr. Makeda, we might just take a short break whilst you try and organise yourself a little better. We'll take So it's now 12:06 Dubai time. We'll come back at about 12:15 or just after.
Okay, perfect.
Okay.
Thank you.
Thank you.
Bye
so
bye.
much.
Yes, Dr. Makeda, we've lost you. Yes, carry on,
Yes.
please.
Sorry for that. Yeah, I needed to charge the also cell phone. I run out of a little bit of battery. Hopefully you can hear me there way better with this microphone.
So far better.
Okay, thank you. Okay. Again, Your Honor, I will make the introduction because maybe it was very
No,
bad.
you needn't do the introduction again. We heard that.
Okay, perfect. Thank you so much. So our issues as tenants, from the premises, they started a little bit before the date Mr. Cholakov was mentioning, backdate in 2022 when they were making all the fit out, that our main contractors start facing issues with the connecting pipes and all of that. That they are the experts. No, that's why we hire them so they can do their work and provide what is necessary and required for the rest. Here in the communication in section, as I was mentioning, in section D, we have the first emails, since
Now,
2022.
section 10, are you referring to your bundle?
Case bundle, yes. It was section bundle under section D.
On what page?
No, in the bundles that I submitted, it's just the list of communication that I submit all the files. Yesterday we have issues and I went to the OC court in person to make the submission of all the documents. Under section D, the first email that we stated, the headline or the header of the email is Chill Water, issue October 2022.
Your Honor, can I just say, I'm sorry to interrupt, but I don't have access to this bundle. Which
okay.
I'm trying to, I don't think we've been provided. So my solicitors, Mesa, have also not been provided with that. So
Dr. Makeda, are the documents in the bundle filed by the claimant?
Yes, I forwarded to the claimant by email indistinctively yesterday in the morning. All of those submissions I submitted as a zip file, compressed, so they have all what I submitted in the e-registry. Yeah.
Who did you send it to?
To Oliver Green, that it was copied in the email from the registry and the registry also.
Yes, Your Honor. So all of that has been included in the bundle from page 490 onwards.
Right.
So everything that's been received by Mr. Oliver Green should be from page 490 onwards, and 490 is the skeleton argument for the defendant, and then all of the documents that have been filed yesterday follow. All right. Is my understanding.
All right. So, Dr. Makeda, all of the documents you provided to the claimant have been put in the claimant's bundle, which you have access to from page 490 onwards. Are you able to identify in that bundle the documents?
Here right now in the DIFC court. Let me log in and try to retrieve it.
You see at page 490 is your skeleton argument, and then after that come various documents.
don't have access.
Alternatively, it might be easier
Mhm.
if is there if there's a single PDF to receive that, but if it's referring to separate, I don't know what your owner has. That is does your owner have different sections A, B, C, etc.? In which case, I think I'll figure it out, because that probably simply refers, I'm told, to the sections as filed by the defendant yesterday. So I have them in separate PDFs, so I can make my way around if that is what is referred
All
to as the
right, let me
defendant.
go. What I've got, I've got a bundle described as defendant's application bundle, and in
Okay.
that bundle, I'll just open that up. It's just going to take a little while to do that.
And I apologize for that, Your Honor, because we have issues trying to submit all the evidence. The registry knew it since last week. They gave me the deadline until Friday, but there was issues with the server.
All right. Well,
So
I've got the bundle, and yes, Mr. Cholikov, it's divided into section A. Wait a minute. Make sure I've got the right note. Yes, it's divided into section A, claim form, application notices, witness statements. No, I'm sorry, that's still your bundle. Let me see if I can find, yes, the defendant's bundle is divided into section A is the claim form and so on, section B, C, D.
So what does section D, for example, have? Because I don't have a section D
Yes.
from the defendant, actually. So
Right.
I'm not sure we're on the same page.
We're struggling.
I will. I'll try to. I think I probably know what the
what is the
Stevens are.
All right, Dr. Makeda.
Yes.
What is it you want to refer to? Something in your bundle, or how can you identify it for us?
Just that is stating that we start having issues with the connections and the chill water flow and everything. Way behind.
Yeah, and that's in an email. And what is the email? What is the email you're referring to?
Okay, give me 1 second. It is. I will point out the exact date and who was in communication. It was. Sorry. So it was in October 26, 2022. The communication was between all the parties integrated. It was Mr. Tayiman from Astoria Global, Sudeep, Waldorf Astoria, a lot of people from Waldorf Astoria, Logic Utilities, our contractors, EHA Technology, stating that we have issues in the connection and that we are not aiming for the required chill water flow rate. No, stated before. As you know, we came in a lease agreement with Waldorf Astoria as our landlord. No? Right now, referring about the pipes and all of that.
No, I'm sorry. We're trying to, for the moment, identify the email. I've got it.
Okay.
And what is the date of the email?
It's October 26, 2022.
October 26. All right, I have an email from Midun Madhu sent on the 26th of October 2022 to George Frank
Correct.
and others. Is that it?
Yes, is that it?
Mr.
Yes.
Mr. Jolikoff, in
I have it there, Your Honor. 182. Is it?
well, I've
Page
got it
one.
in the defendant's bundle at page 289, but it
I've
begins.
got it. I've got.
Yeah, it begins, Dear George, good morning. Thank you very much for your kind support on the project.
Thank you.
Okay.
Yeah.
Yes, Dr. Makeda, you're referring to that email.
Yes, so here it was stated the requirements that were authorized for the chilled water flow based on the metrics of the restaurant, etc., to provide an adequate ambience for the customers. No, it was stated here 17.49.
Now, can I just go back a step? So
yes,
this is an email from somebody at Design Infinity. That
correct.
is your
Our
contract.
contract.
That's your contractor. Is that right?
Correct.
And the email is sent to a number of people who appear to be at Logic Utilities, Strata Global, and I see one at Waldorf Astoria. So it was sent to those parties.
And that Iman,
Oh,
yes,
okay.
a lot of parties from everywhere. No,
All right.
so
Okay.
here is stated that we don't have any control from Strata Global nor Logic Utilities as tenants. We never made any contract with them. The contract was with Waldorf. So the final responsible to help us to achieve all of these things and ultimately will be our landlord. No, and we approached the people appointed by the landlord, Waldorf Astoria or the Strata Global Company, and Victor Champun that was before as appointee by Waldorf and Strata to deal with us directly. So all the communication was always transparent with all the people that was integrated and was dealing with our construction and fit out of the premises. And well, after that submission, yes, after that submission, that we started having difficulties for preparing the venue. Our main difficulties started arising on June 2023. That was the opening. No?
Sorry, did you say your difficulties commenced in June of 22?
When we went into operation, because since October we start facing difficulties in connections and water flow deliveries, but we were not operating the restaurant because it was still in the fit out. And June 2023 was the
June of
restaurant.
23, yes.
2023 was the restaurant inauguration. Okay, so before that, I have stated here one communication by email stating that because we were already spent a lot of money for the inauguration, bringing marketing agencies, an international DJ, etc. for the opening. It was in June. Yes, I have. But in January, we have another email. No, here, June 6th. So before our opening in June 6th, that we were making already the preparations, and I have the file as mail June 2023 Outlook. I don't know if you can.
I have before me an email from Jacqueline Lopez of Tuesday, 6th of June 23 to Sandeep Sukumaran of Waldorf, Astoria and others, which
Correct.
commences. Good afternoon to all. Hope
All.
everyone is doing well. In my defendants bundle, that's at page 302.
Okay, sorry for that. Yes, this is the correct email. In June 6th, in June 6th, here we are stating that at that moment we have chilled water flow of 3.5 liters per second. Okay, here and I am not an expert, but as a witness, I had been reviewing all the information and I have a little bit more clarity in the terminology used about the chilled water flow and everything, and I can explain a little bit more. So the measurements are in liters per second, okay? And every venue will have, according to the design, a minimum flow. According to our contractors and what was approved, the required flow was 17, okay? So we were receiving before the opening, because this was June 6th, the opening was in mid-June, we were receiving 3 liters per second. That means the temperature inside was unbearable. The temperature inside was around 36, 38 degrees. So we raised our concerns right away to the landlord and to all the people in Waldorf Astoria. Victor Chalfun from Waldorf Astoria, that also was appointed as a Astoria Global Manager. So they knew our issues related to the AC. And as is mentioned here, this is a critical situation that needs to be resolved as soon as possible. We don't have control for the chill water flow as tenants. Hopefully we were able to increase it or to make something for us, because we already invested a lot of money in the opening. And unfortunately, this was not solved at all. And we have one third company reading, and I can show the first reading. The first company reading was made in June 17th, and I have as evidence in section D, and the name is test report for Puerto restaurant from the company Trio Bis. So the company went on June 17 to make the measurements.
Sorry, you're now referring, I'm sorry, Dr. Makeda, what are you referring to now? An email?
No, this is an AC company report. Chill water. The name of the company is Trio Bis, and you can find it as test report for Puerto restaurant as an independent file. If you are in a bundle like with all the pages, it's the letter will be water balance sheet, the title, and Trio Bis in the left. So in June 17.
Just bear with us for a minute whilst we try and find what it is you're talking about. Now, I'm not sure. I've got a document, CHW System Validation at Puerto 99 Restaurant DIFC. I'm not sure if that's the document you're talking about.
It will be at the end of that list of documents, because the first one, it was CHW, then the next one is CHWS, the next one is SOR, TA,
yes,
and test report. So right now we have so far.
Which one is it you want the test? Sorry, which one do you want
the
us
first
to
one is test report
Test report, okay. Let me see what I can find there.
Thank you.
All right, so I've got a document now in the defendant's bundle. It's at page 283. It's got TrioBiz LLC water balance sheet flow verification sheet. Is that the document?
Yes, correct.
All right,
So
and what does it show?
here the company measures what is in the left side is main drive. So it's the main measurement from the pipe that we are connected. No?
Mm-hmm.
And in the right side, we can see that it's mentioned size or diameter, brand, design flow 17.49. And then into the right, it says actual flow, liters per second. At that time, in June 16, sorry, the flow was 7.2. Okay, and it says the driver set position, it was fully open. So the valve was fully open. So at that time, we have a flow of 7 from the main pipe. That operationally, it was a disaster for our opening. All the people obviously complained because nobody could wait more than 45 minutes because they were sweating. And there was a lot of people, more than 150 people for the opening, DJs, celebrities, government people. So it was a disaster. We have proof here that even though we try our best to communicate our issues with our landlord at the time, that was Waldorf, that we cannot go and manipulating pipes. No, we request them to make something because our requirements are 17.49. No?
So
Unfortunately,
where did you said you requested them? Where did you request them?
in the email that you just read before, your honor, from Miss Jacqueline.
That one was on the 6th of June. Yes,
correct.
I see.
So we raised our concern because the flow was very low. Then they didn't follow up. They didn't make anything. Then we request one company, external company, a third party, to make the measurement and to have the evidence. So and obviously this communication was served to them. So for this measure, our venue was always inside above 29, 30 degrees. That for a customer and anyone, human being cannot be tolerating this temperature unless for a venue, that you are going to have a dining experience. So far, also from our side, as a family and investors, my brother. So as a little bit of background, as a family, my brother committed a lot of his savings in the fit out and or the construction of this restaurant, around 32 million, in hoping to create something exceptional within the FC. Mr. Chuaco was mentioning that our numbers were.
I'm sorry to interrupt. I just want to make the observation that a lot of this is not in the evidence. So currently, the defendant is giving evidence. I just want to make
at the moment, Mr. Cholikov, nor am I, nor can I see the relevance of it.
Yeah,
but I'm hoping we can move through it.
Thank you. So after our grand opening, we discovered there was more issues with AC, and we tried from that day on to get fixed the AC because we cannot fix it. No, it's something that is out of our hands. From our side, we bring experts, we bring third companies to make measurements to see if there was any other issue. But unfortunately, with these measurements, we were unable to market our venue to grow the business. We have communication all the time with Waldorf in the best hope that they can help us to fix this issue. Why? Because my brother, and as Mr. Cholakov was mentioning in one of our reports, he made a business plan for this venue. It's not that he just went.
And we have the business plan, do we?
We have here as an evidence. One second. In section. I have it and I uploaded as Puerto legal report 2025 compressed because it was.
So what is it called?
Puerto.
Yes.
Final legal report 2025 compressed.
Yes.
Your Honor,
Yes.
I raise an objection
What's
that
this?
this is apparently a purported expert report filed without any permission. I don't know where it is in my bundle, so I'm struggling to see. I'm just
All
doing
right.
instructions.
I'm waiting for it. I'm waiting for it to load onto my bundle so that I can see what it is Dr. Makeda is talking about, and then we'll deal with whether it's properly in evidence or
Well, Mr.
Puerto
Chocolate,
DIFC legal expert report. And it begins the executives. I don't know if you've got this document, Mr. Cholikov.
Yeah.
It's
Chocolate have it there already.
It's called Puerto DIFC legal expert report. In my bundle, I can't see that it's got a page number, but it's the last document in section D for David.
Yes, well, I don't have that section though, but it's being sent to me, Your Honor, as we speak, hopefully. So I might shortly be on the same page.
All right. It says the executive summary. So, sorry, going back.
Yes.
It appears to be a report by NBN Auditing of Accounts. Looking for a date.
Section 2
yes.
is part of the background of the restaurant. And the contractual background.
Not sure if
it was left out.
No, the date of the document. Go to the end of it, perhaps. Might have a date there.
Yeah,
do you know the
June
date
12th.
of this document?
Yeah, June 12th. It's in conclusion, Your Honor.
Conclusion. What page of the document is that?
Is the page 14.
42 of the document.
Okay.
Unfortunately, I don't have page numbers on the document either.
Okay, no, it's in my document. It's on page number 14.
14.
the conclusion, and there's the date.
I see. It's under conclusion. Let me see if I can find that section. Yes, I see. Oh, the 12th of June 2025. So this was completed 12 days ago.
Yes, this one was a report given by.
And when did you give it to the claimant?
Right away, we sent it by email, and I have
On the 12th or 13th of June.
And I have an email for Oliver Green from Mason that they acknowledge they received the
All right.
So here we have a little bit of the background for the financial, the business plan that we have for Puerto DFC. Why? As Mr. Choclaco was mentioning, previously my brother has another restaurant in Blue Waters, and that one we already have a proven concept of a restaurant, which sells around 23 million dirhams per year. Okay, so my brother, with those thoughts, that's why he invested in DFC to make another amazing venue in DFC. Obviously, we know that we will not achieve the same numbers right away, as in Blue Waters with 23 million per year. But it was more a more reasonable budgeting, a business plan for DFC. All the numbers from the expert people are over there. Our sales also are over there. Our sales are at minimum, and that's why it's not that we don't want to pay the rent. We can with these numbers. We are putting from our pockets to pay the salaries, to make everything from our end.
Sorry, Dr. Makeda. Yes. Okay.
Yes.
I'm starting to look through this document. It appears to set out who owns the restaurant. It refers to the lease. And then under the heading Waldorf Astoria's breaches of the lease agreement, it says that providing adequate air conditioning was a fundamental obligation of Waldorf Astoria because paragraph 1.4 of part 1, schedule 2 of the lease agreement states, and then it appears to set out parts of that clause, but not the whole of it. Mr. Cholikov, do you have that available to you? Are you able to follow?
I finally just received it, Your Honor,
Right.
3 seconds ago. I will make observations about the veracity of when it was sent, because it's not true that it was sent on the 12th of June to my sisters, but I think I should probably take it all in reply rather than...
All right.
Yeah, thank you.
All right, and I've noted so far, Mr. Cholikov, on that page headed Waldorf Astoria's breaches of the lease agreement, there's a reference to paragraph 1.4 of part 1, schedule 2. I'm not sure if it fairly or accurately sets out that clause. You might want to have a look.
So here we have a little bit of, sorry for that, about the numbers. We didn't came up with numbers in the venue just by thin air, as stated before by the claimant. It was an already proven concept that we try our best to keep going during this time. We approach all the time to Waldorf and management to get fixed AC so we can have a proper venue for our customers. Why? Because if we have, I don't know, more than 30 customers, it's very, very inconvenient for them inside. And repeatedly, in our best hope to resolve it in an amicable way, we try it. Also, in
Dr.
February
Makeda,
from last,
has the air
yes,
conditioning issue now been resolved?
no, no, Your Honor. At the
So
moment, it's still.
So is the business operating profitably now?
The business, we are operating, I don't know, 20% of our capacity that we could, no, based on the
Well,
AC.
if you were paying rent, would it be profitable?
At the moment, no. That's why we always try
Well,
to
what's the
get solved.
point of continuing trading?
Well, our best wishes was to have a venue,
Yes, but
100%.
I understand what you hoped at the beginning, but I'm looking at now. What
Yes.
the point of continuing trading is now? If you tell me
Well,
it's all, you're just losing money. What's the point of it all?
well, the first point is the first initial investment that we made for the venue, that it was above 30 million from my brother. That's the first concern that we have, that we put all our savings, as Mr. Cholakov mentioned, is our last working restaurant right now. So we want the venue to be successful, recover Puerto 99 branding, a name, so we can have a running business and profitable.
Okay.
Also,
I'm just
yes.
flicking through this document. Oh, I see the figures. I was looking at some profit figures, but that's for a different venue. That's for
Yeah,
the Blue
that's
Waters.
the proven concept that we already have before.
Yeah, right. Where are the figures? Where are the figures for the venue we're concerned with?
It's below that one. Let me. So in the next page, it's stated Puerto 99 DFC sales. No.
Oh, is that on the page? There are no internal page numbers by the look of it, but there's a page that's got a table, Puerto 99 DIFC sales. Is
Yes,
that the
correct.
sales of your venue?
Exactly. That's the sales that we have of our venue in comparison with Blue Waters. No. And everything affected operation.
Are you still able to hear me, Dr. Makeda? You appear to be frozen in my screen.
Can you hear me there? Hello?
Mr. Cholikov, I think, can you hear me?
I can hear you.
I can hear you. Can you hear me?
I think I think we've lost those.
All right.
Can you hear me, Your Honor?
Yes, I think I dropped out there for a moment, but I can hear you again, Dr. Makeda. And I was looking to see the figures for your venue. Is that on the page that's got a table, Puerto 99 DIFC sales?
Correct. That's our current sales.
Right. So it says average sales, an annual figure,
Correct.
is it?
Yes.
On the following page, there's a P&L, and it shows a net loss of 8 million.
Correct.
So at the moment, operating the premises is just stacking up more losses. Is that right?
At the moment, yes, Your Honor. We didn't want this to happen, obviously. That's why,
Obviously. But
yeah, as an investor and businessman, yes.
What's going to change? If I don't,
Well,
if I just a minute, if I do not grant immediate judgment and I allow and I don't grant the claimant the orders it seeks, and you remain in possession of the premises, is that going to result in further losses?
we hope the best that remaining in the premises, we can have a solution and working solution with the landlord to fix the AC, so we can rebuild our restaurant and start with a profitable business.
But from what you tell me, this has been going on for 2 years. What's changed or what's happening now that makes you think it might get fixed?
Well, the first thing that I think could change is the previous manager, Victor Chalfon. He was never supportive towards us. Right now, in his place is Mr. George Al-Asmar. So this change in management can get us someone to cooperate with us, to help us to make something to solve it. Before, Mr. Victor was always blaming us that we don't have any control from the chilling water flow, and even in email communication from last year that I wanted to state it, we requested in February, because we were behind the rental, a payment plan. The payment plan that we offered to Waldorf was to pay at that time 500,000 and the remaining balance in the next 10 months. This proposal was rejected and they wanted the full payment immediately. We told them that we can because of these financial losses for the AC flow, and we requested them to fix it so we can continue and we can have earnings and profit. So it's something beneficial for both. I have the communication, the email communication that I want to point it out.
Yes.
It was provided in February 15, 2024. And well, the header of the email is Puerto 99 Restaurant Lease Agreement Notice of Commencement of Dispute Resolution Process.
Let me just go back and see if I can find that.
Thank you. And the email is from Gusai, our legal representative at that time.
Sorry, what is the date you're talking about? February of 24?
It's February 15, 2024.
Can you give me any clue where I might find it in your bundle?
In my bundle, yes. Give me 1 second. Communication. You can find it as, well, it's RE, Puerto 99 Restaurant Rental Payment Offer 2024 as a file.
Have you actually got your bundle divided into sections and pages?
Into sections, yes. In pages, I didn't have the
All right.
the time.
What section is it in?
It's in section D.
D for David?
D for David, yes.
All right. Now,
Your Honor, I just want to say this section D for David has never, ever been sent to the claimant, ever. So I don't have any of those documents in section D for David.
Dr. Makeda.
Apparently he's found its way to you, but I don't know how. I'm told by the solicitors that they've never been sent that section.
What I can say, Your Honor, our previous law firm, BSA, they put all these, I am using the same files and evidence that BSA was working with Mason and Mr. Cholikov before. And so for sure they should have it over there. And it's an email communication.
Well, we'll see if it becomes necessary to go into that. What is the point of the email you're referring to now? It's February of 24.
24, yeah, 15 of February.
And who's it email from and email to?
It's from Gusai, our legal representative at that time. And it was to Victor Chalfon, that it was the previous Waldorf appointed manager. And to, well, a lot of people, D.L. Piper, Waldorf, Kumar, Mr. Ayman, Tobias Schultz.
Your Honor, this to me, without having seen it at all, sounds like WP correspondence, by the way it's being described currently, between legal representatives about some sort of settlement. I've not seen it. That is certainly what it sounds like to me. And so it's entirely improper if that is double precious correspondence to come before the court.
Entirely improper, did you say?
Improper, yes.
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 Dr. Makeda, what Mr. Cholikov just said to me is that he thinks this correspondence is correspondence between the lawyers trying to reach a settlement or resolution of the case. Now, that may or may not be subject to what lawyers refer to as without prejudice. Until I find the document, yes, I really can't form an opinion about that. That's where I'm trying to find it. But yes, it's a bit difficult.
And I'm sorry that I didn't have it like in an appropriate arrangement, but it was here, the communication they started between both parties, Victor Shafun on name of Waldorf.
Well, if it's an attempt to reach a settlement, I'm not sure how that helps me in resolving this issue.
No,
and perhaps if I just yeah.
Sorry, Your Honor,
my point was just to where I've got to so far from your submission.
The submission, section C. Well, right now so far, just two of our.
Just a minute, please. Just a minute, please.
Yes,
Dr. Makeda. What I've understood from your submission so far is, in essence, you say that the landlord failed to provide or to ensure that chilled water was provided to you in accordance with its obligations. Now, at this stage, you've shown me a report from a contractor which referred to the amount of chilled water that was required and the amount that was actually supplied. You've shown me some correspondence referring to inadequate chilled water. One thing you need to establish, and you may want to tell me about it, is the legal basis on which you say the landlord was required to provide that amount of chilled water, because Mr. Cholikov has said that the lease does not require the landlord to have to provide air conditioning or has to provide chilled water. So you might want to tell me what you say is the basis for the legal requirement for the landlord to provide either air conditioning services or chilled water or whatever it is you say they failed to provide. Because you see, in very simple terms, what I understand you to be saying is the landlord had obligations under the lease. The landlord failed to carry out those obligations, and as a result, that caused losses to your restaurant. Now, we need to start that by identifying what requirement there was on the landlord to provide that quantity of chilled water or whatever it is you say they failed to do. Do you want to address that?
Yes, I want to address that. In the section A, you can find a document that is Annex Industry Practice, Puerto 99, Industry Practice, and referring with the contracts. And as Mr. Cholakov mentioned, we have previously another venues. So also in section, in section E,
you know, just a minute, please. Just a minute, please. Mr. Cholakov, do you know what document's being referred to?
On this one, I believe I do, Your Honor. It came yesterday, and again, I object to its submission before the court entirely.
Right. What is it, Dr. Makeda? Whose document is it? Who wrote
this
it?
This document, I wrote it in regard that we already have other premises rented.
So
and with
you, Jimmy, take a bit of time. You wrote this document. Yes. So this is you saying these things.
Correct. Right. We have the supportive evidence that from the lease agreement provided by Waldorf omits industry standard provisions concerning chilled water capacity.
So I'm afraid I'm lost now. Then it's not the document that I thought I was looking at, so I don't know.
All right. Well, I'll just give you a minute. It's a document. It's got the court heading on it, and then it's got a heading, Annex Industry Practice - Lease Terms for Chilled Water and HVAC Responsibilities.
Yes.
And this is a document you wrote, is it, Dr. Makeda?
Correct. Based on a tenancy contract that we have with Lemiere, as an example. That
based on a tenancy contract you have with another company.
Correct. That is like an example of an standard. No.
But that doesn't help me, Dr. Makeda. I'm not concerned with your lease agreement with another company. I'm only concerned with your lease agreement with the claimant.
With Waldorf. Yes. Well, just to refer to me, my example is in other contracts and other regarding the HVAC and AC systems. Normally, they can point out their maximum loads, the requirements, and everything, and it's stated in the contract. Here with Waldorf, even though it was not stated, as you mentioned, all the landlords are responsible because we cannot modify the chilled water or the delivery of AC to us, no, because we're not the owners or the landlords of the venue. So as a standard in the lease agreements in Dubai, they mention all these items as how do you say, to have more clarity and ensuring an adequate delivery for the specific utilities or well, that is give me 1 second. Yeah, so they need to make a little bit more specifications and operational parameters in their lease agreement.
Well, one view might be if the lease agreement doesn't say they have to provide it, then they don't have to provide it. That might be one view of it.
Yes.
For the moment, I was looking for you to show to me where and why Waldorf Astoria, the landlord, was under an obligation to provide to you that amount of chilled water.
Yes, as obligation as a landlord to provide, yes. Give me 1 second. And this amount of flow, it was the chill water flow requested since the beginning for the venue, for the size of the venue. No, because it's above 6,800 square feet, so it's a big venue. So that's the required amount of chilled water since the fit out. So and Waldorf as landlord, he's obligated to provide us the chilled water. We never made a contract with the Strata.
Just a minute. Why are they obligated to provide you with chilled water?
Sorry, I couldn't hear.
Why are they required to provide you with chilled water?
I know, because they approve the drawings based on the requirements. They knew it, and they approve our requirements.
And is there evidence of that? Have I got the drawings and their approval of it?
Yes, the drawings and the email communication. Let me specify when was. Let me just find it with where it is. One second.
Whilst you're looking for that, I noticed the time. I might just go to the court staff, Miss Alia and others. Are you able to continue for the present time?
Yes, Your Honor.
All right, thank you.
Thank you.
Yes, Dr. Makeda, you said that there were drawings provided to the landlord and they approved it.
Yes, correct. And I want the email, the email that is stated there, that Strata Global and Logic Utilities, they have this approval according to the drawings. I didn't submit
So it
the
was
drawings.
Logic Utilities provided the approval, did they?
And Strata, both, because they were like at that time they were working both together.
Who? Logic Utilities and who?
And Strata Global.
And Strata, what was it called? Strata Global or something, I think.
Strata Global, yeah. Oh, I have
so those two.
One.
So it was
Yes.
those two companies that provided the approval, not Waldorf Astoria. Is that right?
Well, appointed by Waldorf Astoria, because we don't have that authority.
All right. Okay.
So I have it in section D too. The drawings approved are here.
Section B.
Section D.
B for Bravo or D for David?
No, D for David.
D for David, right.
So I have two documents. The first one is the drawings that were submitted. And the second one, the name of the file is email Strata Global to Logic Utilities requesting AC approval. This was on October. Yeah, the approval was.
Just a minute. I think I may have found the drawings, but I'm waiting for them to load on to my computer.
Yeah, it's a large. Yeah, it's a large one.
Oh, is it?
A large file. Yes.
All right. And then there was approval, you say, by
the email. I have it here. Is November 2024. Is all the email communication between Strata, our contractor, Design Infinity, Logic Utilities. The name of the file is email Strata Global to Logic Utilities. And it starts with, and the top is Armando Natividad Outlook, and it's all the communication.
Okay, so I've got the drawing. And somewhere there I find, that there's a requirement of about 17 litres per second chilled water. Do I find that somewhere?
Sorry, again, because I was trying to go with your reading. Sorry, Your Honor.
Well, where in those drawings I've found
you are in the drawings. Okay, let me open the drawing.
a document called Puerto 99 Mexican Seafood and Steak at DIFC Architectural Drawings from Design Infinity. And somewhere there it has
give me 1 second, because in section D should be named. Okay, I have here.
And somewhere there, those drawings show a requirement of 17 litres.
Yes. If you go to the drawings, Your Honor, it says in the bottom, because I put a summary of one of those ones. That is because maybe the one that you have, it has everything included. This one is just specifically for chill water, but I put it as AC04CW CHWS drawings in section D of David. And it's just one page with the drawings.
What's it called?
It's AC-04-CW as a file.
Oh, yes. Okay.
That's just one. Because the other one should have all the electrical things, so it will be more complicated.
All right. Now I've got that page, AC04CW.
Correct. So if you can help me to open that file.
Yes, I have.
This is just regarding the chill water piping layout.
And where does it say there's the requirement for 17 litres per, was it second or minute? I've forgotten, of chilled water.
So if you make a little bit of zoom near it's a section that has like a square near the elevators in the bottom. If you make zoom, there is two connections, the green one and the red one. The green one connection has one, the pipe is like a U, and the right side, it says the diameter of the pipe, and below the flow requires 17.49 liters per second, and it says BOP plus 4,000. So,
all right.
In that
level, now, where does it say who approved? Where does it say who approved it?
This one was submitted as drawing, and in the email that I am telling you, it was approved by Logic Utilities and Strata.
Where do I see that?
The email is the email that I told you. The name is, give me 1 second, just to, okay. As a file, you will find it as email Strata Global to Logic Utilities requesting AC approval. It's a PDF file. It's in the same section, section D, and it's below. It's a 4 file. The number 4 file. It's emailed the
Okay.
Strata Global to Logic Utilities.
Yes, okay. Now I've opened that file, and the
Yeah.
first email is dated
Is
Wednesday, the 26th of October of 2022.
correct. So here's all the communication between George from Logic Utilities, Mindu Madhu from Design Infinity, and Waldorf.
And which one gives approval for the drawings?
Here it says in the number 1 we put chill water, and on the drawing that I show you right now with the requirement of 17.49. The next emails from Mr. George Franks, it says following the technical meetings and identification of applicable risers, we conclude the site inspections.
What email are you referring to? What date and who from?
I know it's in the same chain. It's a little bit down. No.
Yeah. What date?
It's October 24. We go there.
October 24. Thank you for your support this morning. Is that the one?
Correct. Yes. Us with additional drawings. So over there, the drawings were submitted. This was good progress, and I anticipate to be resolved imminently, as we were able to provide solutions paper for all these issues. No, and they stated chilled water, pergola, electricity, and everything. And then there's one email from Tayuman. Okay, and if you go a little bit below, there's another email from George. So also stating, dear Tayu, Tayuman was from Strata Global. We're coordinating with all the parties. It says that they need to upgrade requirements of the chill water load, chill water flow load, electrical load, and the structural load. And one before from Tayuman, it's stating that they cannot understand why the approvals, because they were approved, all of this.
They're saying they were approved.
Yeah.
Where is the document approving them, saying they were approved?
It's the one that I show you, because it's stated in the first email from Design Infinity with that name.
Are you referring to the email from Thayum Manavan of October 20th, 2022?
2026. Is
that the one?
It's Midun from Design Infinity submitted this drawing that I shared with you, with this same name and everything. And this is one that was.
I'm sorry. You're going to have to bear with me. So yes, the one from Mindun Madhu of October 26, but that's from your contractor.
Correct. And
where is there an email from the? Sorry, I'll just go to it. So that's an email from your contractor. And where does it say that the drawings were approved?
Here in the next one from George Frank.
Yeah.
that it says, Mr. Ali, in order to provide drawing proposal, we agree that this will be possible, that this should be possible. And
Sorry, it
Mr.
says, thank you for your support this morning. This was good
Yes.
progress. I anticipate for the queries to be resolved.
Imminently, as we
Then
were
it's
able
got
to
chilled
provide
water following the technical meeting and identification of applicable risers. The Design Infinity team will conclude the site inspections with the help of Mr. Ali in order to provide a drawing proposal for the CHW upgrade. In principle, we agree this should be possible. But where's the
Correct.
approval of some plans?
Here in the next following email, because
Okay.
that is communication between them, between Tayuman and George from Waldorf, no, from Utilities, sorry. It's Mr. Tayuman is stating, in response to your below email, Logic Utilities issue approval and non-objection for the same feed out related to the building.
So it's saying they don't understand how it is that Logic Utilities issued no objection for the fit out without having
Correct.
all the required technical drawings. So they didn't approve the technical drawings because they didn't have them. They approved the fit out.
Yeah, the fit out that it was included with the
All right.
with the drawings, and then later the contractor made the submission of all the requirements from
Okay.
Logic Utilities.
All right. All right. What's the next point you want to make?
The next point, sorry. Well, the next point is that we try to resolve this issue constructively with our landlord to get it fixed and have a proper venue. And we paid, as mentioned by Mr. Cholakov, rental for almost 1.2 million, including the deposit.
When did you pay rent? When did you pay rental up to?
Up to October, August 2023.
Now, you said you've tried to reach a resolution,
Right.
but you haven't paid any rent at all since August of 23. Is that right?
Correct. Yeah. In February, we tried the resolution. Well, the settlement. Well, not settlement, but to came with a payment plan that at that moment
Why didn't you make some payment?
We make the we make the settlement. We tried to make the settlement.
So you were
Waldorf
able to
denied.
make some. So you're telling me you were able to pay some rent?
Yes, we asked Waldorf to pay.
Well, just a bit at a time.
Yes.
So in February is this February of 24 you're talking about?
Yes, February 24.
Okay. So at that time you were able to pay some rent, were you?
Yes, we were trying to get how do you say? I'm sorry for missing the words in English.
That's all right.
But we were trying to reach a resolution to start paying the rental. We asked them, please help us to fix the AC so we can start generating a little bit more, because that payment will come from our pocket, so to speak.
All right. Well, tell me, why have you not paid any rent since February of 24?
Because of the sales, Your Honor. The sales, as you saw,
But you told me you were. That's why I asked you. Were you able to pay rent?
At that time, we were able to make a commitment with them to make a partial payment, and they denied completely. And they told us that
I just want to get this clear.
Yes.
In February of 24, were you able to make a partial payment of rent?
Right.
Why haven't you done that?
our only request was they could help us with the AC. That was our only request.
Oh, so I'm still trying to understand this. You were able to pay some rent, but only if they helped you with the AC. Is that right?
Why? Because we are not having the issue ongoing. No, we're not fixing the problem, and our cells will continue in the same position. So
Oh, I understand that, but I'm trying to understand this, Dr.
yes,
Mercator. I think I'm not sure if I think you may understand what I asked you. You told me that in February of 24 you were able to pay rent, but I'm not sure if you're resigning from that position or not.
well, it was not as expected by Waldorf, the amount, no, from our side. If I cannot explain perfectly, no.
No,
But
no, I
from
don't think
our
it's a
side,
language problem, Dr. Mercator. Let's start it again. In February of
yes,
24,
correct.
were you able to make a partial payment of rent?
Yeah, we were trying our best to make a partial payment.
Yeah, and you, well, you've not directly answered my question. Were you able to? Did you have the capacity? Would you have been able to do it?
At that time, a partial payment, yes.
Why didn't you?
Because at that time, Mr. Victor, that we were in contact, the previous manager, he refused everything. He wanted the full payment. If not, it will be not feasible, and it's in the
Well,
email correspondence.
that's because, is that because there were some conditions you put on making a partial payment?
Well, we the only thing is, as since day one, we just needed a working venue with the proper AC. That's the only
All
thing
right.
we were looking.
All right, I don't think I'm going to get any further with this. All right, carry on, Dr. Mercator.
Thank you. Well, after that, we operated in good faith. We put from our side portable fans and everything to increase the temperature in
What do
our
you mean
venue.
you're operating in
Obviously,
good faith? In a sense, we're harping back to our previous discussion. You said you were operating in good faith, but you didn't
yes,
attempt to make any payment of rent at all, did you?
yes, in the hope that they can help us to fix the AC so we can work and we
Yes,
can
yes,
have
but in the
revenue.
absence of that, you weren't willing to pay anything unless things changed. Is that right? Unless they did something to fix the air conditioning, you were not willing to pay anything. Is that what you're saying?
Yes, because we submit the evidence, Your Honor, that the problem for the air conditioning was not in our hands at all.
And your position remains, does it, that you're
Uh,
not willing to pay any rent now unless
no,
the air conditioning is fixed to your satisfaction? Is that fair?
no, we want to pay, and we have been
Well, why
always
aren't you
open.
paying? If you want to pay, why don't you?
Well, in December also we have another meeting with the management regarding the same issues, but unfortunately there was a complete denial from Victor Shafun and the
But
management
you
at that
don't
time.
need their permission for you to pay them. You could just pay it, make a partial payment if you wanted to, couldn't you?
Yes,
But you choose not to do that. Is that correct?
yes, because we don't have any support from our landlord regarding the main issue.
Okay.
But if that is the case, that we can make the payment and then I don't know if there is requesting. I don't know if that works better. That if we pay and then we request, but um, we never thought that we needed to make a payment to receive something that should be done from day first from the first
Okay.
day.
Yes, okay.
That we are willing to pay, yes, and we approached the management in December again to have some arrangement in a payment plan, but again was denied, denied for completely. we showed them that the revenue was not as should be because of the AC, that we wanted to make a payment. This was, Mr. Cholakov maybe doesn't know about this, but it was a Zoom meeting with management. I am telling you because I was a witness, that's why.
Well, perhaps you better not go through that because there may be some constraints, legal constraints on that. I was just asking you about your about your financial capacity to pay.
Correct. Yes, as I am.
And do you tell me yes or no? Do you have financial capacity to pay either the whole or part of the rent?
Partial, yes. At the moment, just partial.
All right. But you don't have the financial capacity to pay all of the rent.
At the moment, no.
Okay.
If we can have a help from the court or from the landlord to give us a little bit of time, we can make it.
What? Sorry, just say that again.
No, that if we have help from the court or from the landlord, we can
help to do
we
what?
can have a little bit of time to make the payment, the full payment.
Why? Yeah. How is time going to help you to make the full payment?
Or maybe with a payment plan from now onwards, and the commitment to help us to improve the AC flow.
Yeah, well, that's the point, isn't it? It's nothing to do with time or payment plans.
No.
What you're saying is, unless and until the air conditioning is for your satisfaction, you can't pay the rent. Is that right?
No, what I'm referring is we want to pay the rent. We cannot in a full amount. No. Once we make the payments and everything, we request also to be helped from this side so we can improve ourselves to make any modifications. If we need to make any other modifications from our side, put external units, we need to figure it out and work with the landlords to improve our situation.
And have you requested to do that? Have you put external units on?
No, we haven't put external units because also those ones need approval. Yes, from the landlord.
All right. Okay. All right. What's your next point, Dr. Makeda?
What we made so far, it was just putting like cooling only fans inside that they don't require any approval to improve a little bit in our side. So we want from all our heart and soul with a payment plan. So it's not that we don't want to pay. We are not with the finances currently with the restaurant is very difficult. We are willing to pay. We need a little bit of time so we can improve our venue, invest again in the venue, put maybe air conditioning or external units, whatever is needed, again, the marketing. But once we can restore our place into a full capacity, and our customers, they feel comfortable.
All right. What else did you want to say?
Oh, nothing else. Just that we have the reports from AC. We have more reports for the AC. I don't know if it's needed to discuss right now, but we have in total 5. In all the,
I'm sorry, you have what? I couldn't hear you.
In total, there are 5 AC reports. I don't know if you want to go in all of them, but all of them they say the same. No, the flow is way below what is stated.
All right. All right. Anything else?
Nothing else. Just your help to have our venue in and have a good relationship with the landlord to work around and have a teamwork. That's the only thing that we want. And to be here.
Thank you, Dr. Makeda.
Thank you.
Mr. Cholikoff in reply.
Thank you.
Your Honor, I've got quite a lot of points, given what has come up, but I don't think anything that has been suggested by the defendant changes the analysis and the defense of equitable set-off. First of all, I should observe, I mean, from taking things from the last point that's made, this is obviously not a mediation. It's not an exercise of the court helping the defendant make payments. As we discussed previously, the contract's terminated. The music has stopped, and they need to leave. But in terms of the evidence that's been, or the purported evidence that's been submitted, first of all, let me begin with this suggested expert report that was put before the court. Now, first of all, it was said that it was given to a defendant on 12th of June. That isn't true. As far as I understand the situation, it was filed with the registry on the 17th of June, on the Thursday, and as part of an exchange in which my sisters objected, because this was described as a court-appointed expert report to the registry by the defendant, my solicitors objected and said there's no such thing, and objected to its admission. Unfortunately, it didn't make its way to me, but I've got it now. My submission on this is that it's not worth the paper it's written on. Worse, it is entirely misleading, because in my submission, it's made of numbers that are made up, given what we've heard just from the defendant right now. First of all, this report is called, if you go to the first page, I don't know if you've got it in front of you, Your Honor.
I'm waiting for it to load. Yes, I have it.
Well, first of all, it is supposed to be given by an entity called NBA Auditing of Accounts. So it's supposed to give the aura of a reputable accountant who's given an independent auditor's report. The language and tone and what is put in there is as far as it gets from an independent auditor's report. It is basically a mouthpiece for the defendant's arguments. It uses language along the lines of fatal breaches of fundamental obligations. There is no expert auditor with any duties to the court who would ever write these statements. It says on its face legal expert report. Again, that is a nonsense. The legal experts are the advocates and the judge, if they even can call themselves that. There is no such thing as a legal expert appointed to the court. But anyway, what is most concerning in all of this is if we look at the numbers that are being put forward, that is on page, internal page of the report 11. And then
I can't see internal page numbers. Where do you see them?
Well, I don't. My software tells me what it is. There isn't one document. But
right. What's the heading on the page, or
financial implications? And it's got the tables in blue of numbers. Puerto 99 blue water sales. Now,
yeah, I've got it.
Now, these numbers do not have any factual support in the annexes from where they come. There aren't any accounts, any audited spreadsheets, any data that supports those plucked out of thin air tables that we see here. And the worst thing is, regardless of what the true position is about Puerto 99 blue waters, it is entirely irrelevant, because that is a separate restaurant. Even if the business case for that restaurant is reflected here, it doesn't matter, because it's a different entity. But as far as this case is concerned, if we go to the next page.
Yes.
These numbers simply cannot be right, because what we just heard from the defendant is that the defendant is able to make at least a partial payment of rent. But from where? Because if we go to the next page, according to these numbers, it's got a net loss of 8.3 million dirham. And so in my submission, what's happened here is that these numbers have been made up to support the unsupportable contention, or the unsupported by evidence contention in the witness statement by the defendant, that they've received about 100,000 dirham per month. That's where this is come from. There is no basis for it. There's no support. There's no accounts. There's nothing at all by way of evidence.
That that loss is calculated by having included a payment of 1.4 million for rent.
Well, I don't know what that is.
No.
I don't know for which year this is. I mean, it says annual. I mean, it's just it lacks any weight of credibility as a document.
Yeah, yeah.
I mean, look at the language, Your Honor. I mean, it's the second paragraph below the table. The Waldorf Astoria's fatal breaches of its most basic obligations under the lease agreement. I mean, there is no independent expert who would write this. And ultimately, Your Honor, you took the defendant at incredible length to ask him to show you any basis for this most basic fundamental obligation. And the best thing that he could do is a self-written report by him on industry standards that's not in evidence, and it's not even been suggested, based on other leases that they've got with other buildings. That simply cannot fly. I understand that the court ought to award some latitude to litigants in person, but even that has its limits in the procedure. And I think those have been stretched, and I don't know further than that. Now, in terms of the other points that I just want to make in reply, the best case scenario we've got here, according to the defendant's evidence, is the company is entirely insolvent, and therefore there is no hope.
What leads you to that, saying that the company is insolvent?
Well, according to their own evidence. I can't. I mean, these numbers, if they're taken as they are, they show a net loss of 8 million. So it's unable to meet its rent payments, it's unable to meet its obligations, but also it's unable to pay its lawyers. Let's not forget that the only statement that we know is true in terms of their financial position. We know two statements that are true. I don't know. I suggest that no way to reliability should be placed on the veracity of these numbers that they made up. But there are two statements that the court can rely on. And they're one by the former solicitors, BSA Law, which have said that there is no hope, no real prospect that their fees are ever going to be paid. That's number one, that statement must be true, and there's no reason to be doubted. And it's by officers of the court. And the second statement that is true, because it's undisputed by both parties, is that every other restaurant has shut down. So from the entire group's revenue, the only restaurant that keeps operating is this one. It is a very good reason. It pays no rent. And so it keeps going for free. And it's very clear that the strategy of the defendant is to keep going for free for as long as it can. And so these numbers are not credible. There are probably other numbers that show a very different position, because no restaurant will operate for 2 years amassing such massive losses and just keep going on the hope that something changes. Clearly that cannot be true.
Yes.
And overall, I mean, I don't need to take you in detail to any of the procedural points, but I think I need to state the objections on the record. And that there have been a number of documents in the so-called Section D that have never been sent to the defendant. There have been documents that have been sent without permission and out of time, such as this purported legal expert report, which should not be admitted because they're out of time, but they lack any probative value because of the points that I've already made. We've heard of self-written expert reports by the defendant on industry standards, where industry standards has not been taken as a point in issue in the evidence. And so if it was suggested that the industry standard is why the obligation comes from, then that should have been taken in the evidence, and it wasn't. And so we're working on the basis that their entire case is on the contractual provisions, and we couldn't find them. And then fourth, there was potentially without prejudice material that I haven't seen, so I can't say whether it is or it isn't, but it certainly sounded like it, so it should not be before the court. And so all this material should not be relied on. And where that leaves us is
just a minute, please. Dr. Makeda, are you still with us? Dr. Makeda, can you hear me at this time? All right, we'll pause for a minute. Ah, yes.
No. Can you hear me? Sorry.
Yes, I can. Thank you. Yes, continue, Mr. Jolikoff.
Yes, well, I'll refrain from the latitude that is given to the demeanor of the defendant to comment on that latitude, demeanor of the defendant, and the treatment and what that shows in terms of the respect for the court. But the last point that I want to make is that where that leaves us in terms of the defense of equitable set-off, it is no further than my submissions. And ultimately, if it were available, there is no legal obligation upon which the counterclaim can fit into the same case as the possession claim. But as far as the formal element is concerned, and as far as the functional element is concerned, there is quite simply a significant number of reasons why the defendant should not be assisted by equity given that behavior. And I think the point at which I want to end on is that we heard from the defendant that it is operating in good faith. And in the best way to describe that is, or the most generous way to describe it is disingenuous. A defendant does not operate in good faith by coming in and forcibly, under false pretenses, in an act of thuggery with 15 people, re-enter possession of a property it knows very well it doesn't have right to do. Because if it did, it wouldn't have done so under false pretenses. And so that is as far as it gets from behavior that should be aided by equity, as one can imagine in these circumstances.
Yes.
Unless I can assist Your Honour any further.
No, thank you, Mr. Jolikoff, and thank you, Dr. Makeda, and I am sorry to the court staff, and thank you for continuing to sit on during the lunchtime. That I will reserve my decision and let you have it as soon as I can. Thank you all. That concludes today's hearing.
Thank you, Your Honor.
Thank you.